I'll call this meeting of the Harlan Township Board of Trustees in order. As a reminder, the meeting is being video and audio recorded. And please don't forget to sign in. Would you please stand and join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Jenny, would you please read the minutes from the previous meeting and also the special?
Board of Trustees of Harlan Township met in regular session the 6th day of November 2024 at regular meeting place of 8276 State Route 132. Trustees Edward Prudzynski, Kevin Kern, and Marcus Shelton present. Meeting called to order by Mr. Shelton at 7 p.m. Mr. Shelton asked all present to stand and say Pledge of Allegiance. Minutes read from regular session October 16, 2024. Mr. Kern made a motion to approve minutes as read, seconded by Mr. Prudzynski. Assistant Chief Mason reported engine 81 out of service for repairs at Atlantic for regular maintenance and addressing several water leaks, possible wiring issues, and pump test. Mr. Shelton made a motion to approve maintenance repairs not to exceed $8,000, seconded by Mr. Prudzynski. Mr. Mason reported Warren County Engineer's Office, Assistant Township Road Department removing 11 trees along Pleasant Renner Road. Mr. Mason reported Road Department winterized restrooms at Whitaker Park and preparing equipment for snow removal. Mr. Mason discussed Philip Hampson's last day for seasonal employment was October 31st, now moved to intermittent employee. Mr. Mason ordered cabinets for the required AED. Mr. Mason ordered 2 AEDs, one for Whitaker Park and one to be placed at Butlerville and Gym, costing $4,312.62. Mr. Shelton made a motion to approve required purchase, seconded by Mr. Prudzynski. Resolution 110624-1. Mr. Shelton moved to adopt resolution for emergency plan action for the use of automatic external defibrillator by public and chartered non-public schools, youth sports, organizations, sports, and recreation locations as required by House Bill 47 of the 135th General Assembly, Ohio Revised Code 3701.851, seconded by Mr. Prudzynski. Old business, Mr. Prudzynski attended the Warren County zoning meeting on November 5th, discussion at meeting about solar regulations for the county. All solar permits will go through county for approval. Mr. Shelton discussed the DAR event at Edwardsville Cemetery. Township was given flag from Washington, D.C. New business, Mr. Prudzynski will attend the Warren County Township Association dinner on November 7, 2024. Mr. Shelton asked status of the Tahoe from Warren County Sheriff's Office. Mr. Mason stated still working on getting vehicle ready to be placed in service. Ms. Williams received email from Warren County Auditor's Office requesting Township to place dog license information on Township website. Trustees agreed to post. Ms. Williams will forward email to Mr. Mason to have placed on the website. Ms. Williams discussed changing current 3 part-time salary employees from semi-monthly to monthly salary. Ms. Williams spoke with Mr. Mason and he stated had no problem with changing from semi-monthly to monthly pay. Mr. Shelton made a motion to change part-time salary employees from semi-monthly to monthly pay, seconded by Mr. Kern, who will readdress if have issues in the future. Mr. Shelton asked Katie Horvath from Warren County Prosecutor's Office to explain the investigation of Chief Bennett. Ms. Horvath stated the Board of Trustees appointed a private citizen to investigate charges made against Chief Bennett. Frank Williams was appointed investigator and completed report, then delivered to trustees November 5th, 2024. Mr. Mason delivered a copy of report to Chief Bennett on November 5th, 2024. Chief Bennett Legal Counsel has asked for continuance to discuss at next board meeting on November 20th, 2024. Mr. Kern made a motion to grant continuance to November 20th, 2024, second by Mr. Prudzynski. Roll call, Mr. Prudzynski, yes. Mr. Kern, yes. Mr. Shelton, no. Mr. Shelton made a motion to remove Chief Bennett from paid leave to unpaid leave effective November 6th until results of the November 20th, 2024 meeting, second by Mr. Kern. Roll call, Mr. Prudzynski, yes. Mr. Kern, yes. Mr. Shelton, yes. Mr. Shelton made a motion to approve Township Administrator Steve Mason permission to supply requested documents or other requests for information on behalf of Township for the investigation. Mr. Shelton made a motion to appoint Steve Mason or Jamie Whitaker as acting fire chief, seconded by Mr. Kern. Mr. Shelton discussed need to have a fire levy committee start to explore needs for fire and EMS for township. Mr. Shelton requested Mr. Mason to contact members and start meetings. Mr. Shelton discussed firehouse remodel. Mr. Brzezinski would like to work on this project of remodel, window replacement, and other possible repairs needed. Mr. Shelton asked about the design that was made for remodel. Laura Mueller from Harvest Design stated believes design taken to architect. Trustees do not believe submitted to architect. Community comments, Peggy Brown asked for verification of the unpaid leave and the continuance. Susan Bitzer asked if township would continue snow removal for Village of Butlerville as in past couple of years. Trustees agreed. Bridget Ballard received rental from Butlerville for basketball on November 7th and has received a request for use of gym for baseball from January 9th to March 20th, 2025, however, has not received paperwork. Mr. Shelton made a motion to go into executive session pursuant Ohio Revised Code Section 121.22G1 to consider employment, dismissal, discipline, promotion, demotion, or compensation of road department employees, seconded by Mr. Brzezinski. Roll call, Mr. Brzezinski, yes. Mr. Kern, yes. Mr. Shelton, yes. Mr. Shelton made a motion to adjourn executive session, seconded by Mr. Brzezinski. Roll call, yes. Mr. Brzezinski, yes. Mr. Kern, yes. Mr. Shelton, yes. Mr. Brzezinski made a motion to increase hourly wage of Larry Burchett $1.20 per hour from $24.60 to $25.80, effective November 9, 2024, seconded by Mr. Kern. We had no correspondence. Ms. Williams gave written financial report to trustees. Mr. Kern made a motion to pay bills, seconded by Mr. Brzezinski. Mr. Shelton made a motion to adjourn, seconded by Mr. Brzezinski. Meeting adjourned at 8:39. I have to get a drink. I'm sorry. The special meeting called to order by Mr. Shelton. Special meeting on November 19, 2024. Special meeting called to order by Mr. Shelton at 4:13 p.m. Mr. Shelton made a motion to appoint Steve Mason pro tem, seconded by Mr. Brzezinski. Mr. Shelton made a motion to go into executive session, Ohio Revised Code Section 121.22G1, to consider the investigation of charges or complaints against a public employee. G3, conferences with an attorney for the public body concerning dispute involving the public body that are the subject of pending or imminent court action, seconded by Mr. Kern. Roll call, Mr. Brzezinski, yes. Mr. Kern, yes. Mr. Shelton, yes. Mr. Shelton made a motion to adjourn executive session, seconded by Mr. Kern. Roll call, Mr. Brzezinski, yes. Mr. Kern, yes. Mr. Shelton, yes. Mr. Shelton made a motion to adjourn meeting, seconded by Mr. Kern. Meeting adjourned at 5:56.
Do either of you have any corrections or additions to the regular minutes?
I do not.
Motion to approve the regular minutes as written.
I can second that.
And do either of you have any corrections or additions to the special meeting minutes?
No.
Do I have a motion to approve?
Motion to approve the minutes of the special meeting.
Second that.
Thank you.
There are two places here on this
Yeah.
one.
Yeah, you just have to.
You can sign this in.
Yes, please.
Steve, are you ready for your report?
Yeah, I'm just gonna, due to time constraints, I'm just gonna save everything over for the next meeting. Don't have anything pressing, so we're just gonna hold that over.
All right.
Excuse me, as a resident of Harlan Township, could you please speak up? I hear you out here.
They just want you guys to talk louder if you could, so they can hear you out there.
We
Please,
don't have microphones.
just project a little more. You guys are just talking quite quiet, if you could. Thank you.
All right, do we have any, old business?
I have none.
I have none.
I have none.
I did not have any.
No.
Do we have any new business?
I'll save those for the next meeting.
I have none.
I have none.
No new.
We need to do the organizational meeting at the first meeting of December. So, whatever that date is, and I'll have all the paperwork ready for that. It's something we do every year.
First meeting in December.
Yes.
During the meeting.
Yes, it'll just be during a new business. All I have.
Community comments?
Yes.
I have something from the last meeting, because we spoke about the remodel.
Yes, and I owe you an apology because you were so adamant about that. I went home and looked it up. It was a May 1st meeting. You were correct.
Yes, and I'd like to just tell the residents what's happening in that project, because I think it's important, and I think you left out a lot of information that Dusty Bennett's been working on that you're really not giving them credit for. So we spoke last meeting, for those of you that didn't watch the video, about the Station 81 remodel. And I had noticed that you left out several meetings that pertain to the architect that Harlan Township has hired for this position.
We have not.
We haven't
I have not made a contract with him.
Well, you also have meetings where it was reported that you're working with them, and you did not know that you were working with an architect. So I'd like to go through those individual meetings that I read back and read the meeting minutes for, where you reported that Dusty Bennett did not report to you that he's been working with an architect, or that you were working with an architect. So when I went back through the 2024 meetings, I noticed that during the April 17th meeting, Chief Bennett reported to the trustees that he will be doing a walkthrough of the station with architect Jeff Watterson to review the design and complete an itemized sheet for the renovation. During the May 1st meeting, Chief Bennett reported to the trustees that he has met with architect Jeff Watterson to review the plans and discuss the layout. Mr. Watterson will be contacting the building department with questions prior to submitting an estimate for the drawings. During the June 5th meeting, Chief Bennett reported to the trustees that architect Jeff Watterson had ADA guideline questions for the building department and had messages into the building department and was waiting to hear back before proceeding. During the July 3rd meeting, Chief Bennett reported to the trustees that he had received 2 sets of drawings from the architect for Station 81 renovation, and he was setting up a meeting to discuss before submitting. So I find it incredibly hard to believe that you have zero knowledge of the stage in which you are in this remodeling process because of those meetings. And so why did you say in the last trustee meeting that Chief Bennett never reported information to the trustees about an architect when he clearly did? Were you withholding information from township residents with an intent to make Chief Bennett look bad? Or do you lack the ability to retain information that is reported to you during these trustee meetings?
Which is even all the more better because you've got notes and they're in writing and they're right in front of you in that red book.
And you said, and I quote, "It was never reported to you." And that's in Jenny's meeting minutes from the last meeting.
Right, and that's why I just apologized to you because it was in the May 1st minutes.
There's several minutes that you
More than
talked
just May
about.
1st.
Right,
They
so I
reported to you.
mentioned the dates that we had discussed it, but there was not a discussion on the architect's name until May 1st.
You claimed that you still hadn't been working with an architect. And he has been telling you Jeff Watterson from April 17th to July 3rd. And I find it hard to believe that you can't remember that name. I was not involved after April 17th when you paid me. My part was done, the preliminary was done, And these drawings were getting handed over to an architect so that you could proceed with getting with the building department, getting the permits that you need, and getting the project in process.
Right. And
Why
there
were you
was-
acting like you were still waiting for information from Harvest Design Co? And then you're saying, I'm sorry, I owe you an apology, but what about all those meetings from April 17th to July 3rd that you forgot to mention? Are you trying to make him look bad? Like
No,
he hasn't been doing anything?
absolutely not.
Him and myself worked very hard on this project. And I was really proud of it. And I
we
haven't ever
appreciate
met
it.
you before. And that was a terrible first impression.
No, and like I said, I apologize. You were correct. It was mentioned in the May 1st minutes. And Mr. Puginski
The
has.
April 17th, the May 1st, June 5th, and July 3rd.
Well, I found them in the May 1st minutes. That's what I'm
Okay.
trying to say to you.
Yes, I just want to make sure that you know, they were in several meetings, so I
Right.
don't understand.
We've had a lot on our plate this year. I just, yeah, not a full house.
Right. Let's leave it on that.
Has there been any township money paid to this architect at all?
No, I met with Jeff Watterson this past week. Jeff, wherever he is, Jeff and I met with him to see where he was on the design. He gave me two different, basically sketches.
My experience, they don't do much of nothing until they get paid.
Right. And I asked him for an estimate, and he had a lot of questions that he wanted to get resolved with the county. I called the county immediately.
So is that a yes or a no that any township money has been paid to this
We haven't
person?
paid him anything.
Okay.
So I have his two sketches, and until I get a price to make sure that this is gonna be covered and we have something that's usable, and we get his questions answered from the county, which I already have for him, then we can proceed.
But no money has been paid to this person at all.
No,
But it was in the process.
I have two sketches right here.
Any other comments?
So none of you have had contact with Mr. Waters since
I
July,
met with him last Wednesday.
since July 3rd?
Since before the last meeting.
Dusty's been working with Jeff Watterson and Harvest Design.
No,
Why so-
I have not been involved in this at all. I have not been involved since April 17th. I don't know Jeff Watterson. I've never met him. My part was strictly just to provide a design to you guys so that you could visually see what you could do with the interior of that building without putting an addition on. Because if you ever work with an architect, they're very expensive. And if you aren't even gonna get involved with the remodel, why bother getting involved with an architect until it's time? So you guys had to approve the idea of a remodel that these, and the main guys, Dusty, Steve, and Jason, they wanted to do the remodel and they wanted to show you what they could do to help save the community money and do a remodel to provide those living quarters instead of adding on to that building.
And they've done that.
Yes, and he did a very nice job. Thank you, Chief Benham.
Sir, are you aware that there are multiple firefighters who respond to calls in materials and PPE that are more than 12 years past their suggested lifespan?
We're all aware. Are you speaking to me directly?
Anyone? So how many times has Chief Vinup asked you to figure out a way to get the gear up to date?
We're constantly working on that.
For 12 years?
That's been going on forever. I mean, we work on that all year. They try to get grants.
So you're asking our firefighters to go into a burning building wearing PPE that is not up to code, that is potentially life-threatening to the firefighters.
I'll jump in here. I don't, I don't want to speak for Chief Vinup here, but, him and I have both been involved in some of this ordering, along with Lieutenant Stiles, and we have tried very hard to keep people. And in fact, I think most everybody was up to date as of the last cycle. Chief Bennett has approved we try to get 5 sets, trustees have approved about 5 sets a year as we can. We have a FEMA grant that we've also used to try to pay for some of that fire gear as well. So to my knowledge, there aren't a lot of people. Now during training, we do have issues sometimes with new people. We have quite a few new people come in. We do not have new gear to put them in necessarily, but as as part of a large scale number of firefighters not having proper PPE, that would fall under Chief Bennett's role, and he's done well with getting those 5 sets of gear or more as we can. Obviously, we're on a limited budget, but as far as having a large number of people who don't have proper PPE, I would say that is incorrect.
So if a firefighter reports to you that their PPE is either broken, inefficient, or out of date, what is your immediate response, sir?
If they report that if there's gear that's damaged, we send it out and try to do things. If we have a firefighter now that's going through training, he's one of our new people that we recruited. He had to go through training with gear that was outdated, which makes a lot of sense. There's no reason to put a set of brand new gear on somebody who's going to spend the next 180 hours of his training crawling around on the ground and ruin a brand new set of gear. Brian, what is the new set of gear roughly?
I think we're outfitting somebody for about $4,000.
So we're not going to spend $4,000 and have them destroy it. So this firefighter's going through training now. He did not do any live fire exercises. The Career Center mandates that all firefighters that go through that training go through live fire training. They inspect the gear, the gloves, the boots, everything, and it has to be up to current standard, which is a 10-year standard for NFPA. Don't ask me the actual code precisely. But we do not have a large number of firefighters. I said that would fall under Chief Bennett's responsibility to make sure that his firefighters are equipped properly. And I believe that the majority, up to our capability, are equipped properly.
But not 100%.
What's that?
But not 100%.
Active firefighters that want, and we were, I'd have to look at the roster. I don't know. It is near 100%. Yes, sir.
What is your definition of near 100%? I guess my
it's
question
your
is,
number. I'm just saying.
I guess my question
Chief,
is this.
I don't believe that Chief Bennett or myself intentionally put firefighters in danger by not having proper PPE. If that's what you're alluding to.
But if you have knowledge that you have gear that is expired and you're not replacing it, and you have knowledge that you have firefighters wearing gear that either doesn't fit or is broken and has been reported and is not fixed, and you're not fixing it, you are putting people in danger. Maybe not by intention, but I'm going to tell you right now, there is no consequence for safety. If you have a firefighter that you knowingly have in outdated gear who goes into a house and dies, guess what happens? The township goes bankrupt.
The fire chief is sued first. Yeah, and I don't know what you're getting at with this. We do our very best, and Chief Bennett does his very best to try to keep our people in proper gear. And we have a limited budget. We operate on about $500,000 a year.
Mm-hmm.
And yeah, at one point we were very close to having everybody 100% in proper PPE. Go ahead, Brian.
I'm in charge of gear.
Yep.
In the last round, back in right at the fiscal end of last year, we started cycling through to have reserve in-date gear. Because you can't equip an entire department in one shot. So we were filtering out gear from 06. So everybody that has cycled through that is actively running as a fireman has in-date gear.
Right. Now,
if a person doesn't want to make entry or a person doesn't meet run obligation, that's a different discussion. So we have spare gear in date.
Okay. Just doing the math roughly. How many firefighters we got? 35-ish, 30.
Give or take.
Times 4,000?
Roughly, I can't tell you down to the penny. Let's say 4,000. Sure.
He's just trying to figure out why I still have a helmet from 2003. And when I asked for a new one, I was told we didn't have the money.
And her helmet, by the way, her helmet's broken. It has broken straps. She's asked for it to be repaired at least 5 times, and it still hasn't.
So I would say that's a question for another time. It's very likely we're going to be here until midnight or 1 o'clock as it is. So if you have brought that to somebody, it's not been intended to. That's a question outside of this trustee meeting. I believe the overall subject certainly applies as far as does Chief Bennett supply his firefighters with the appropriate PPE to fight fires. I will say, yes, he does.
I know he does.
If you're implying that he doesn't, then
No,
that's
he was
your own
going somewhere
prerogative there.
else with that.
But
with that
I will say that for our staffing, Lieutenant Stiles, myself, we try to do the best we can. Obviously, we have limited people that are paid to be there. We do the best we can. If that's something that you tell what's outdated, you should have followed up regularly with that with Lieutenant Stiles, myself, Chief Bennett, and that could have been taken care of. So that's my answer for you
He was
there.
going somewhere completely different with that statement. You just didn't let him speak.
I'm not gonna be listened to anyway, so I'm just,
I'm just giving you the facts. There you go.
the facts are is that there's still people operating with equipment that is 12 years past its expiry date. And that's not right. And I'm not looking just at you, Steve. I'm looking at all the trustees because at the end of the day, who approves for the fire department to get the money to buy the gear? Right?
Well, the chief asked for it. So if you're gonna, and again, I don't agree with you that Chief Bennett doesn't do a good job.
No, I know he does.
I know
Well,
he
that's what
does.
you're saying. So
No, I am absolutely
just so
not.
you're aware of structure.
What I am saying is that the trustees.
We're here because he sent out an email that had to do with the levy that he's been fighting so hard for. And we know that Dusty fights hard for our fire department. And that's why we're here.
So is there a complaint with the gear against Chief Bennett then?
No,
is that
we're here because we know Dusty fights hard for our fire department. And what he was trying to allude to is that we're here because of some stupid email when we know Dusty fights hard for our fire department.
So
And I don't know, he had a point that he made.
I'm not sure how that ties back to your neck strap on your helmet.
I don't know.
Exactly, but
He had a point. He made it earlier and it made a whole lot
At
of
the end
sense.
of the day, you know, we're looking at our chief for what appears to feel and has touch and feel of you know, he's going to be accused of something like dereliction of duty or whatever, and yet I'm looking at the board of trustees who haven't even served our firefighters wholly just to keep them safe.
Well, I
And
have
if
a
you
question.
said-
So hold on, I'll ask this question and
You're gonna tell me there's a price on safety?
Well, I got a question. Have you ever denied Dusty anything
That
he's
was my
needed?
question.
I've
Have the trustees ever denied you asking for gear?
never. I've never heard of
Sure,
denying
sure.
anything. Anytime he's asked for something, they've talked to him and he's given it. Never.
But then.
This sounds like a personal matter. I say we move on to what's
It's gonna be a long night. And again, I would just reiterate this, that I will back up Dusty's dedication to firefighter safety because that is his job. That's his main job as the fire chief, to keep everybody safe. And I will say he's doing the best job with the resources available to accomplish that job.
Any other comments?
I'd just like to say, I've been to the meetings and I've heard Dusty ask for things and you guys have supported him. So I think this comment is far beyond what we're here to discuss. So there is mutual support on both parties for that situation. And I've been to the meetings, majority of them.
Do I have a motion to pay the bills?
Make a motion to pay the bills. I'll second that.
Correspondence?
We do not have any.
All right, at this time, we are prepared to have a hearing pursuant to section 505.38 of the Ohio Revised Code. On September 21st, 2024, the trustees appointed a private citizen investigator, Mr. Frank Williams, to look into an allegation of misconduct by Chief Bennett. Mr. Williams has completed his investigation and has served a copy of the written report and charges on the Board of Trustees. Has the board had an opportunity to review the report prepared by Mr. Williams?
Yes.
Chief Bennett, have you been served with a copy of the report and the charges?
Yes.
All right, do you wish to stipulate the contents of the report or do you wish to proceed with a hearing on those findings today?
Mr. Shelton, Matthew Alangoni, and Justin Whitrow on behalf of Chief Bennett. We do not stipulate to the report, and we wish to proceed with a hearing at some point. Now, we have requested an extension to that hearing based on the fact that the request for subpoena documents and public records, which we sent, I believe, on November the 8th, was not fulfilled until 2 days ago. So we got several hundred pages of documents, 34 gigabytes of data served to us from the Warren County Prosecutor's Office just less than about 48 hours ago. Have not had a chance to go through all of that. So we put in writing a request to the trustees for an extension to the hearing to be able to review those documents.
Let me just interrupt a note for my client, for the board. For the record, this is Katie Horvath from the Warren County Prosecutor's Office. That request was a public records request. 33.5 of those 34 gigabytes was YouTube videos that they wanted of the meetings dating back to January of this year. So all of those have been available this whole time. They've been aware that those have been available. So that's something for you to consider in your decision about whether to grant this request. Additionally, a lot of the documents that they requested, I mean, they requested a volume of documents. They sort of created this when really this centers around one document, right? This whole hearing. So, you know, take those things into consideration when you're considering whether to grant the request.
And if I may just add, Chief Bennett was served on November 5th with a 4-page investigative report. There are several documents that the investigator stated that he reviewed as part of this investigation, but those were not included when he was served with the report. So we requested anything that the investigator considered in drafting this report. That was not provided, so we had to put in a subpoena request and public records request for those documents.
Have you received those documents?
Less than 48 hours ago.
All right, well, I guess that's a question for us then. Chief Bennett's counsel has requested another continuation. And they're here tonight, but they still want to do a continuation.
Second continuance.
This would be the second. I guess the motion, I mean, we'll you have to pass a motion. Do we grant the continuance? Is there a motion to grant the continuance or to deny the continuance?
Yes. We had discussion about that. And we consult with.
So,
You kind of gave us our
Yeah,
options.
I pointed out one reason to you, but you all need to make that decision on your own.
So we already granted a continuance on November the 6th until November the 20th, which I believe there is something about the 15 days or something in the ORC.
Right, so the chief is currently on a suspension based on the date that you placed him on suspension. The 15th day is today. That can be extended another 15 days, which would go out to the 4th, which is the day that I believe that they're requesting the extension. Is that correct?
The next township hearing or board of trustees hearing.
So the next township meeting, regular meeting is the 4th, correct?
Yes.
So that would be allowed under the statute. The hearing would have to be held by that date because you're not allowed to have him on a suspension longer than the 30 days.
Are you available on the 4th?
I am not available on the 4th. So my recommendation would be if you're considering granting the continuance, you should schedule a special meeting, do it here on the record with everybody's calendar so that we can get that special meeting scheduled before the 4th.
And does the investigator, do you be available on the 4th?
No, I'm out of town that entire week. So, hey, I can show you my flight to New York.
All right.
Anybody has questions?
Mhm.
Can you, other than reviewing this information?
And just for the record, I'm available next week. I'm just not available the week of December 2nd.
Katie?
You're looking for my availability.
Next week's Thanksgiving. And
I'm available Monday and Tuesday of next week.
As a township residents, can we request if you do the continuance to have this in a facility that will house the people in the hallway?
So the reason I can answer this one, I guess. The reason it was in here is that there's a request for it to be recorded, video and audio recorded. This is the only room we have available to do that. It looked into to try to move it into the gym. The problem we have is with the upload speed, it has to be hardwired. I cannot upload it fast enough via Wi-Fi. That's been tried. So anything that we would move, we'd have to have, communication company come in and run wiring somewhere to where my computer sits in order to have the upload speed needed in order to live stream the meeting. So that's why it was kept in here. There was a request for it and it needed to be video
Does the
recorded.
Blue Miami gig that supplies this, rent this building?
It is. It just comes down to having to drill holes in walls and get that done in a timely fashion and be able to test it. So it's not just, we can't just run a cord this long all the way along and strap it down and then we have a fall trip risk and things. So
they
yes.
only rent 2 rooms.
But they're in the building, correct?
Learning Academy, they rent the other end. So, I mean, and they can't be in there during the day. The only time they can do it on the weekends or
Does
nights.
the firehouse have this technology?
No.
The second is my only available day that week.
What is that?
It's a Monday.
Monday.
Yeah. December 2nd?
You're gone that week.
Yeah, I'm not available Monday morning.
So it looks like our options are the 25th or 26th. What do you have?
That right before Thanksgiving?
Yes.
It's Monday or Tuesday.
This Monday, 26th.
Yeah. Next meeting, I guess I'm jump back to the. I think, look, given that schedules are tight with Thanksgiving and all the other logistical issues, we will maintain our objection to receiving these records just 2 days before the hearing, but we are prepared to, in an effort to streamline this process, we will proceed with the hearing today. But we, for the record, we are maintaining our objection to being served with these documents and records just 2 days before the hearing.
So note their objection for the record and you're withdrawing your request for continuance?
Yes.
All right, we will move forward with the hearing then. We have Assistant Prosecuting Attorney Catherine Horvath present as statutory legal counsel to the Board of Trustees. We've asked her to advise the board on conducting this hearing in accordance with the law. I'm going to turn it over to her to advise us on how to proceed.
Okay, I just want to put a couple things on the record ahead of time. This is for the benefit of the board. This is for the benefit of Chief Vinup, for everybody who's here listening, so that everybody understands how we're going to have an orderly hearing today. The board does not do these types of hearings very often. They act in a quasi judicial capacity in very rare circumstances. This is one of those circumstances. So I'm going to be here as their statutory legal counsel to advise them on how to conduct these proceedings. My role is to provide legal assistance and guidance along the way to make sure that they are able to hold a fair, impartial, and quasi-judicial hearing. I'm going to assist them in allowing the investigator to present any evidence that he has collected in his testimony. And I'm going to assist them in ensuring that the chief is able to also present everything that he has to present today that's relevant to the charges against him. I don't represent the chief, obviously, in these proceedings. He has two attorneys here, Mr. Withrow, correct? And Mr. Halandoni. Did I say that correctly?
Yes, thank you.
I don't represent him. They do. I don't represent Mr. Williams. He's a private citizen who's been appointed as a third-party investigator. I represent the board. My advice to the board should not be construed as any opinion that I'm giving in this case on any of the facts. I'm just advising them on how to conduct this proceeding in a fair way. Trustee Shelton has kind of summarized where we are in the proceedings so far. There is a statute that says we have to conduct these proceedings this way. I'm going to restate that again just for the record. Section 505.38 is what gives the Board of Township Trustees the authority to appoint firefighting personnel. That statute also says those appointees shall continue in office until removed from office as provided by section 733.35 to 733.39 of the Ohio Revised Code. To initiate removal proceedings, and for that purpose, the board shall designate the fire chief or a private citizen to investigate the conduct and prepare the necessary charges in conformity with those sections. So that's what the board has done so far. They've appointed Mr. Frank Williams as a private citizen to conduct the investigation. They couldn't appoint the fire chief because the investigation involves the fire chief. So they had to go with an outside party, third party investigator. It's my understanding he's completed that investigation. He's prepared a report with charges outlined in his report. He's delivered that report to the Board of Trustees. He's also delivered the report to the chief. Then when we go to these statutes, that the first statute is a township statute, and it directs us to some statutes that are usually used by municipalities. And so those are the statutes that we're following today in conducting this hearing, because that's what we're required to do. That one of those statutes says charges filed with the legislative authority shall be heard at the next regular meeting thereof, unless the legislative authority extends the time for the hearing, which shall be done only on the application of the accused. The charges that were prepared by Mr. Williams were delivered to the township on November 4th, 2024. The next regular meeting of the township was November 6th, 2024. So with 2 days notice, the chief requested a continuance of the hearing so that he could be present and have his legal counsel present. So the board granted that request. They continued the hearing to today, which is the regularly scheduled board meeting of November 20th, 2024. So today the board is proceeding with the hearing as provided in 733.36, and that section says the accused may appear in person and by counsel, examine all witnesses, and answer all charges against him. And I'm going to advise the board that it takes a 2/3 majority vote in order to remove, demote, or issue a disciplinary suspension to the chief. If after the proceedings today, and after you hear all the evidence, the board does not vote by a 2/3 majority to remove, demote, or suspend the chief, then he's going to resume his position as fire chief of the Harlan Township Fire Department. If the board does vote to remove, demote, or suspend the chief, he's going to have an opportunity to appeal that decision to the Common Pleas Court by way of an administrative appeal. You are going, at the end of hearing all the evidence, you are going to make factual findings in support of your conclusions about the evidence on the record and in writing following the hearing. Here's how we're going to proceed. The chairman of the board, which Trustee Shelton, that's you, correct?
Yes.
You will conduct and control the hearing. There is not going to be any public participation in this hearing. The board's required to conduct this hearing in an open session, but they are not required to allow the public to participate. You're not going to be allowed to interrupt. You're not going to be allowed to ask your own questions. You're not going to be able to make comments as participants unless you're called as a witness. I'm going to recommend that we start off by making the investigator's report an exhibit. Are you okay with that being a joint exhibit?
Yes.
Is it okay if we call it Exhibit 1? Can I label it that way?
First letter.
Yeah, ours are lettered,
So that's fine.
Okay, I'm going to call it Exhibit 1. And then anything that Mr. Williams wants to present, he'll use numbers.
That's fine with us.
That works. And then we're first going to hear from Mr. Williams as your first witness, or I recommend that you call him as your first witness. He's going to be sworn. Every witness is going to be sworn today and give a summary of his report and his findings. Then, after Mr. Williams presents what he has to present, the chief is going to have an opportunity to present anything that he wants to present. He can call witnesses one at a time and ask them questions. They will all be sworn in. The board will do all the swearing in of the witnesses because they have that authority in this proceeding. I'm going to swear people in.
No.
Yeah, I think Trustee Sheldon can do it either way. The board opportunity to ask questions of the chief or any of his witnesses, just like the chief's going to have an opportunity to ask questions of Mr. Williams after he's presented his testimony. After the chief presents his case, the board should ask Mr. Williams if he has anything that he wants to redirect, so correct or change about his testimony. Or if he has any response to anything that the chief raises. And then the board is going to deliberate and make a decision. I'm going to advise you that you are required to deliberate in public. That's going to be tricky for you, but we'll get through it, all right? It'll be tricky just because it's hard to, as a judicial body with private thoughts on the evidence, et cetera, it's difficult to articulate all of those as you're discussing it with each other, because you may have, you know, certain things that you're weighing differently than one of your colleagues, and therefore that's hard to articulate and kind of muddle through. But we will ask you to do that. Here's some other points I just want to make. It's already close to 8 o'clock. This could go late into the night. If you need a break, or if you need a break, if any of you need a break, just ask the board and they will happily, you know, take a break for a minute. I would ask that you don't ask for a break in the middle of somebody's testimony. We're recording in a couple of different ways. So we have the regular YouTube recording that's going on. We also have Ms. Williams, the fiscal officer, has a handheld recording device over there on her end of the room. I'm recording on my cell phone right here close to me and close to Mr. Williams, hoping to pick up our voices clearly. And I understand that Mr. Halandoni might also be recording, or Mr. Withrow. So we have several backup methods of recording going on. Because we are recording, we cannot have people talking over one another. There may come a time later where we have to write down everything that was said in this hearing. We might have to have a transcriptionist do that. A transcriptionist will not be able to hear people talking over one another. So I'm going to ask for us to try to keep that to a minimum, right? Or not at all. Don't talk over each other. Ask a question, let the person answer before you begin talking again. Let's see. Because we're recording, it's important for everybody to speak up when they're testifying, when they're asking questions, when they're making argument, when they're ruling on things. It's also helpful if a speaker, when they begin speaking, can identify themselves for the record. Again, if somebody later on is trying to listen to this and write it all down, they need to be able to know who's speaking. So that's difficult to remember to do, but if you can try to do it, that's helpful. Generally, I'm going to recommend that the board use a loose form of the rules of evidence. That means we're going to allow in a lot, right? You're going to let him present whatever he wants to present. If the evidence starts getting duplicative, if it starts getting outside the scope of the investigation, that kind of thing, it's okay to take some measures to try to limit that. But otherwise, our loose form of the rules of evidence is going to be the way that we're conducting this proceeding, allowing one side to present and cross-examine, and the other side and cross-examine. If there's any objections that are raised and you all need assistance in ruling on those, I'm happy to advise you on what the objection is and how you should rule. I might interrupt frequently, but again, nothing that I say should be construed as an opinion on how you should decide the facts of the case or what is presented. My legal advice to the board is not testimony. It shouldn't be interpreted as such. The trustees need to listen to and review all the evidence. They are going to decide what's reliable, what's credible, what they believe, what they don't believe based on what's presented to them in the hearing. So, with those rules, did I miss anything? Are there any rules you'd like to add in addition to that?
Well, with the cameras and everything rolling, like even when we swear witnesses in, so everybody just kind of stays seated during the process.
Okay. So I think let's go ahead and mark the report as an exhibit. Is it okay if I use my copy?
Fine.
Okay. I'm gonna mark this as 1. And then Trustee Shelton, if you'll swear Mr. Williams in, we'll get started with him.
Mr. Frank Williams, will you raise your right hand? Do you swear or affirm that the testimony you're about to give in this proceeding today is the truth, the whole truth, and nothing but the truth? I do. Yes. You stated your name, Mr. Williams. Will you state your name and spell it for the record?
Franklin Williams, FRANKLIN WILLIAMS.
And for the record, how were you contacted and notified of your appointment as a private citizen investigator in this matter?
I received an email notifying me. Yeah, I have it printed out here. On Saturday, September 21st, I received an email from you informing me that the Board of Trustees made a decision to appoint me as the investigator.
We need to mark that as an.
Do you want to mark that?
Sure.
I recommend you do.
And by the way, what I have here, again, I'm kind of going off, there's no script here, but I provided all of my investigative documents on a thumb drive to Mr. Mason. So there may be pieces of information that I don't have printed out here, but I've already provided it. And so if there may be something that we may want to admit or discuss, but I just don't have it on hard copy. It was a lot of information. I wasn't sure if I was going to need it, so I didn't print everything because a lot of it was just random emails.
Okay, so if that comes up, I'm sorry, I'm gonna interrupt.
Yeah.
If that comes up, I do have printed copies
Oh,
of
okay.
everything that you have, so if there's something that anybody needs to reference, I likely have it in this binder.
Okay.
Okay,
Thank you.
go ahead.
Ms. Williams, have you had any other experience in your personal or professional life that make you equipped to conduct a workplace investigation? And can you describe that experience?
Yeah, I printed out, I wrote up a little bio. I figured somebody, either yourself or the Chief Vennup's counsel would be asking about some of my qualifications. So, so anyway, I'll just go ahead and read this. I knew it was going to come out at some point. So, yes, I'm a retired, highly decorated U.S. Air Force veteran with 20 years of honorable service to our nation. During my military career, I worked in command and control and intelligence roles, managing some of the Department of Defense's most sensitive information under top secret security clearance. I was responsible for managing emergency communications with the Pentagon and implementing critical actions in response to global security threats, requiring precision, discretion, and sound decision-making. I frequently collaborated with the Judge Advocate General Corps on cases involving professional misconduct and compliance with federal regulations, including matters related to the handling of classified information. This work required a high level of accountability, attention to detail, and the ability to assess and document facts in complex situations. And in my civilian career, I've held leadership and executive positions in both startup environments as well as multinational corporations. These roles have included contributing to the resolution of sensitive workplace matters such as intellectual property concerns, employee performance issues, and contractual disputes. My responsibilities often involve reviewing and providing documentation, ensuring compliance with policies, and navigating complex organizational challenges. Across both military and corporate settings, I have approached every role with integrity, professionalism, and a focus on fairness, particularly in addressing sensitive personnel issues. Thank you.
Prior to your appointment as the investigator, did you know Chief Vennup?
Yeah, I met Chief Vennup approximately 1 year ago at a township meeting. It was right after, it might have been the December meeting of last year, and it was in the other building. And Chief Vennup and I were sitting there, and we were discussing. It was the first time we both met, and he invited me to join the levy committee. We were discussing the levy committee, and subsequently, I think either he or you or someone organized, several people to get together and discuss possibly putting another levy on the ballot sometime this year. And so that was the first time I had ever met him. And subsequent to that, my meetings with him were probably, I would say, eight, maybe 10 times. And it was a professional setting where we were getting together as part of the levy committee to discuss, as I said, potentially putting another levy on the ballot. That's the extent of my connection with him.
Despite knowing him through that process and despite your experience with him, were you able to remain impartial in conducting this investigation?
Yeah, absolutely. As I already stated, my intentions all along are to be fair, to be impartial, to look at the evidence, to be a fact finder, and report where the evidence takes me.
We have read your summary report, but will you please provide us with a detailed description of how you conducted this investigation and your factual findings related to the charges?
So once I was appointed, as the private investigator, I wanted to, my first priority was to clearly define the scope of the investigation. So I scheduled meetings with the three trustees independently, so that I could get their specific direction around the scope. And the scope was clearly stated that there was an allegation that Chief Venep had disclosed attorney-client privileged information without authority from the board. And however, that was the initial scope. And if anyone's read the report, you can see that some of the findings that I've documented have kind of expanded from that. However, that's where the evidence was taking me. Those things unfolded as part of the investigation. They weren't really part of the initial scope. So that's why I included them in the report. So I met with the trustees to find the scope. I also met with Steve Mason, and I requested to meet with Chief Venep. I did eventually meet with him as well, with his legal counsel present. So then the next part, after I had, gotten clear direction on the scope, I requested from all parties, and let me define all parties, from the trustees, from the prosecutor's office, from the auditor's office. I requested copies of all emails and text messages that had occurred throughout this year regarding any issue. And then I followed that evidence and came to the conclusions that I came to after I had interviewed everyone and reviewed the emails. And then subsequently, I don't remember the exact date, I'm sure it's in the report, that when I met with Dusty and his counsel and finally got access to some of that information from Dusty's side.
Could you name the individuals that you interviewed in this process?
Yeah, I was going to ask, are we going to, I printed out the report. I know you already submitted it. Is this something that we could read, should read? Because I'm not sure, for the benefit of the public, if they even know what the report says.
It's allowed if you want to let him read it into the record. That's fine. He's under oath now, so it's going to be a sworn.
Are you guys good with that?
No.
All right, go ahead.
Okay, because this report does also answer your question of who I interviewed. Okay, so, all right. And this report is public record, right? So it's
correct
from the day I submitted it. So this report presents the findings of an investigation into alleged misconduct by Harlan Township Fire Chief Dusty Venep. The investigation was initiated following concerns about the unauthorized disclosure of attorney-client privileged information related to a ballot language issue for a proposed levy for the November 2024 election. The scope of the investigation encompassed, number one, the circumstances surrounding the disclosure of the privileged information. Number two, Chief Venep's handling of township-issued devices and accounts. Number three, Chief Venep's cooperation with the investigative process. Through interviews, document reviews, and examination of electronic devices, this investigation uncovered multiple instances of unauthorized disclosure of confidential information, deliberate deletion of potentially relevant data, and a pattern of non-cooperation with the investigative process. This report details the chronology of events, presents key findings, and provides an analysis of Chief Venep's actions. The evidence gathered raises concerns about Chief Venep's adherence to professional standards, compliance with township policies, and respect for legal and ethical obligations in his role as fire chief. So the interviews that I conducted was Kevin Curran, trustee, Ed Brzezinski, trustee, Mark Shelton, trustee, Steve Mason, township administrator, Dusty Venep, fire chief, with his legal counsel present. The materials that I reviewed emails and text messages between the Harlan Township officials, Warren County Auditor's Office, and the Warren County Prosecutor's Office. I reviewed video recordings and the minutes of the Harlan Township trustee meetings from February through October of this year. The Harlan Township laptop and mobile phone assigned to Chief Venep, Harlan Township email account, which was chiefvenep@tds.net, Harlan Township public records and retention policy, the Harlan Township fire chief job description, and the employee handbook. The timeline of the key events on April 17th, by the way, all of this is 2024. So on April 17th, the trustees approved a 3.5 mil levy for 5 years for the November 2024 ballot. On August 30th, the incorrect ballot language was discovered stating the levy was going to be for a continuing period. On September 3rd, Attorney Katie Horvath sends an attorney-client privileged email outlining the options to the trustees, the fiscal officer, the township administrator, and the fire chief. On September 4th, Chief Venop shares the contents of the privileged information with the fire department personnel without authorization. September 18th, trustees placed Chief Venop on paid administrative leave. On the 21st, the investigator was appointed. On the 22nd, Chief Venop transfers township issued phone number and associated data to personal account without authorization. On the 25th of September, Chief Venop forwards privileged email to a lawyer in Cincinnati. That was the same attorney-client privileged email. On October 4th, the investigator requests emails and text messages from all township officials. That's also including the prosecutor and auditor's office. On October 11th, the investigator contacted Chief Venop to request an interview. On the 15th, Chief Venop was directed to meet with the investigator. Also on the 15th, Chief Venop forwards that privileged email to his personal AOL email account. On October 17th, Chief Venop returns the wiped township laptop and cell phone. On October 23rd, the investigator gained access to Chief Venop's township email account. On the 28th of October, the interview was conducted with Chief Venop and his legal counsel. On November 2nd, Chief Venop sends copies of 7 text messages to the investigator, that's me. And on November 5th, the investigative report was completed. So I go into key findings. The unauthorized disclosure of privileged information. Chief Venop repeatedly disclosed confidential information from an attorney-client privileged email without authorization. On September 4th, Chief Venop copied the contents of Ms. Horvath's privileged email and sent it to various fire department personnel without authorization from the board of trustees. On September 25th, while on administrative leave, Chief Venop forwarded the email to a lawyer in Cincinnati. And on October 15th, Chief Venop forwarded that privileged email to his personal AOL account. These actions constitute a breach of trust and confidentiality, as the information was designated explicitly as attorney-client privileged and confidential. The next section is deletion of potentially relevant data. Upon reviewing Chief Venop's township devices and accounts, it became clear that extensive data deletion had occurred. Upon examination of Chief Venop's returned township laptop on October 17th, all emails and web browsing history had been deleted. The township issued cell phone returned by Chief Venop on that same date had been wiped clean of all data, including emails, text messages, and call logs. Chief Venop admitted attempting to erase the phone before returning it to Harlan Township, claiming he wanted to transfer the data to his new device. The trash folder in Chief Venop's township email contained only 5 days worth of emails. Chief Venop admitted to deleting the emails, which could potentially be relevant to an ongoing investigation. Deleting data raises concerns about the willful attempt to obstruct access to records and impede the investigative process. The next section is obstruction of the investigation. Obstruction of the investigation. Chief Venop exhibited multiple instances of non-cooperation and delay. Number 1, Chief Venop failed to respond to multiple email requests for information in a timely manner. Number 2, on October 15th, Chief Venop was directed to meet with the investigator on October 17th, but he failed to do so. On October 21st, Chief Venop's attorney stated that Chief Venop would provide the password for only one of his township accounts, claiming he didn't remember the password for the other 2. Number 4, after more than 4 weeks, Chief Venop submitted selective records, omitting messages with Township Fiscal Officer Jenny Williams and Trustee Kevin Curran. Number 5, the fact that Chief Venop provided no messages with fire department leadership, who would likely have discussed the key issue vital to their department, raises suspicion as such communication would likely have provided valuable context for the investigation. These actions delayed the investigative process and suggest a pattern of non-cooperation. Then unauthorized actions. Chief Venop's handling of township resources further highlights inappropriate conduct. Number one, on September 22nd, which is one day after the investigator was appointed, Chief Venop transferred his township issued phone number and all phone data to a personal account without authorization from or discussion with the Harlan Township Administration. Number two, Chief Venop forwarded township related emails, some of which were confidential and attorney-client privilege, to his personal email account, despite his attorney's statement that he had no township records in his personal accounts. This pattern of handling township resources underscores a lack of regard for the boundaries between public duties and personal interests. So the analysis of Chief Venop's behaviors. Number one, disregard for confidentiality. Chief Venop's repeated disclosure of attorney-client privileged information demonstrates a lack of judgment and a disregard for the confidentiality required in his position. This claim of not seeing the attorney-client privilege label in the email subject line is not credible given the prominence of such markings. And in addition, there was also another, this is not in the report, but that email also had confidential at the bottom. So it was in the subject line and it was also at the end of the email. Obstruction of the investigation. The timing and nature of Chief Venop's actions strongly suggest an attempt to impede the investigation. Number one, the transfer of his township phone number to a personal account occurred immediately after the appointment of an investigator. Number two, the deletion of data from a township device and email accounts took place after requests for information were made. Number three, the selective and incomplete provision of text messages raises questions about the truthfulness and completeness of the information provided. Then lack of transparency. Chief Venop's inconsistent statements, particularly regarding township records in his personal accounts, and his delayed and incomplete responses to information requests demonstrate a lack of transparency and cooperation with the investigation. Misuse of township resources. The unauthorized transfer of the township phone number and data, as well as the forwarding of confidential information to personal accounts, indicates a misuse of township resources and a blurring of professional and personal boundaries. The conclusion. The preponderance of the evidence supports the conclusion that Chief Dusty Venop, number one, knowingly disclosed attorney-client privileged information without authorization on multiple occasions. Number two, deliberately deleted data and attempted to impede the investigation. Number three, failed to cooperate fully and transparently with the investigative process. Number four, misused township resources. These actions constitute serious breaches of professional conduct. Recommendations. Based on the findings of this investigation, it is recommended that the Harlan Township Board of Trustees, number one, consider taking action in line with Ohio Revised Code 733.35 for misconduct in office and malfeasance. Number two, review and strengthen policies regarding the handling of confidential information and the use of township issued devices and accounts. Number three, implement mandatory training for all employees on maintaining confidentiality, proper records management, and ethical use of township resources. And number four, consult with legal counsel on the following Ohio Revised Code statutes for applicability to this matter. The first one is Ohio Revised Code 2921.12, which is tampering with evidence, deleting and concealing records during an investigation. The second one is Ohio Revised Code 2913.04, unauthorized use of property, misuse of township issued devices and email accounts. Respectfully submitted, Franklin Williams.
Can I make a recommendation?
Yes.
I would ask him to clarify, I mean, because he's stated the ORC 733.35 misconduct in office and malfeasance, which are general reasons that the board is allowed to discipline an officer. But it sounds to me like the specific charges are number 1 through 4 under the conclusion. Ask him to clarify that.
Could you clarify that, Mr. Williams? Yeah, the charges themselves, right. Number 1, knowingly disclosed attorney-client privileged information on multiple occasions, yes. Number 2, deliberately deleting data and attempting to impede the investigation. Number 3, failed to cooperate fully and transparently. with the investigative process. And number 4, misuse township resources.
Thank you. Do any other board members have any questions for Mr. Williams, the investigator?
No.
Have a copy, do you have a copy of the information that was forwarded to the community?
Yes.
Is it an exact replica of
Yeah.
what was sent by Ms. Horvath?
Yes, and this is the attorney-client privileged email. So I have this email before I get into this. I have an email that was sent to me from Mark Shelton on October 4th, informing me that as the investigator, that the Board of Trustees voted to approve the release of confidential and privileged information to me for investigative purposes only. So that's why I have access to this email. Okay, so
During your investigation, did you get the actual copy of what was out in the community?
yes, I have that here. This email is from Chief Vena, dated Wednesday, September 4th at 4:42 p.m. I do have that email, and it is, so what this email consists of is Dusty sent this to what appears to be firefighters. I know most of them. I was cross-referencing them with the rosters. Some of them I'm not 100% sure of, but I believe they're all firefighters. But what Dusty, what the email that he sent, he sent a preamble, his own little opening paragraph, and then he sent then he copied and pasted from Ms. Horvath's original email the attorney-client privileged information into this email that he sent to. He didn't forward her email. He copied it, the contents of her email into his own email. And so I have the one that Dusty sent, and I also have the one that Ms. Horvath originally sent as well.
Do you all want those marked?
Yeah.
Do you
I'd
all?
ask things those.
Yeah.
Did
Here, this one is Dusty's.
Did the recipients of Chief Bennett's email know that was attorney-client privileged?
There is no indication on that email that Dusty sent that it's attorney-client privileged or confidential.
Hey, can you clarify?
Yeah, I'm doing it backwards, actually. Okay, so the chief's email I'm marking is Exhibit 3.
And this is your email.
Yeah, and my email I am marking as. You didn't mean to hand me this.
Oh, okay, sorry. You're welcome.
I say that already. That clear?
Board have any other questions for the investigator at this time?
Not.
Does the chief have any questions for the investigator about his report and findings?
We do.
Should I swear in chief? Is chief?
No, I'm just.
No,
be
he's gonna,
prosecuting.
his attorney's
Okay.
gonna.
I don't have to do this.
That's all right.
We do.
Mr. Williams, good evening. How are you?
Could you state your name for the record?
My name is Matthew Hollandoni. I'm counsel for Chief Vena.
Fantastic.
Mr. Williams, we met before. Is that correct?
Yes, we met, I don't have the date, but yeah, we met one time when I was interviewing Dusty.
And we didn't really get a chance to talk much. I didn't know much about your professional background, but I heard you state that you're an Air Force, retired Air Force veteran.
Yes.
Well, thank you for your service. I myself, I'm a lieutenant colonel in the Army Judge Advocate General Corps. And so, when you talked about some of these investigations, it's something that I obviously understand and know a lot about as well. So thank you for your service on that. You said you retired. What rank did you retire at?
I don't mind stating, but I don't know that it matters.
I'm just trying to get some background here.
Senior Master Sergeant.
Okay. So, what was in the Army, we call them MOSs or?
It was AFSC. The Air Force Specialty Code is the equivalent of the MOS. So I held several of them. Initially, when I first went in, because, as you're probably aware, people can retrain. So throughout my 20 years, I held 3 different AFSCs. Initially, I was in communication, and I became first sergeant, and that's when I spent most of my time with the JAG, as you can imagine. And then I finished out my career in command and control and intelligence.
And during your time in the military or otherwise, did you have any formal legal training?
No.
Okay. Were any of your specialties related to law enforcement? Were you OSI or security forces?
No.
Were you formally appointed to conduct investigations during your time in the military?
Formally appointed, no, but I materially participated in several of them. Being in as a first sergeant or as a superintendent in the command center, as you can imagine, being material witnesses to collect data and provide testimony. But yes, most of those were led. They were all led by the JAG, as you can imagine, right?
Or an officer that was appointed as the investigating officer?
Well, the ones that I dealt with were all JAG related.
And then you said in your civilian career you conducted several investigations.
No, I have not conducted. I have materially participated.
So by materially participating, are you saying? Can you explain that a little further?
I apologize if I cut him off. Right. So. Yes, materially participating, again, providing documents, providing evidence, providing narratives, analyzing the situation, providing my feedback to the people that are leading the investigation. So in the corporate world, that's typically human resources. Occasionally, there will be some, the corporate legal counsel may be involved depending on the situation. But again, they're leading it and they're gathering data from various parties.
So it sounds like you were more of a witness to those investigations.
I wouldn't say witness. Well, depends on the situation. Sometimes it was a witness. Sometimes it was someone that was providing data.
So you were asked for data as part of that investigation, and you provided what you were asked for.
Right.
But you were never the one actually conducting the investigation.
No.
So
well, not leading it. No.
So is this the first investigation you've ever conducted as the investigator?
Yes.
Do you have any training in digital forensic examinations?
No.
Do you know what those are?
I can assume, but it's probably digital forensics. I kind of know about it, but no, I have no training in it. I didn't think that this situation rose to that level because, I had lots of questions that went unanswered because, but I didn't, around potential data and data deletion and forensics to try to retrieve that data. But again, as a private citizen, my assumption was that in order to even go down that path would have potentially required legal subpoenas. And I don't know that we're really not talking about a capital murder case here. We're talking about emails and the deletion of data. So in my opinion, it didn't rise to that level. So I didn't make it an issue. I looked at what was before me, or in this case, what wasn't before me.
So you discussed initiating the investigation. You stated that you received an email on September 21st from Trustee Shelton. Is that correct?
Correct.
All right. Was that the first time you heard anything about this investigation?
No.
What other communications did you have about this investigation?
The The investigation, I'm trying to remember the sequence of events. Let me look at the dates here. Yeah, I was appointed on the 21st. I believe Mr. Shelton contacted me prior to that. I believe it was a phone call. It was probably just a couple of days before that to ask whether I would consider being an investigator. And that was the extent of it. And I said, yes, I would consider it. And then I didn't hear anything else until I received that email.
And on that initial phone call, what did Mr. Shelton tell you about this investigation? What was that?
I don't recall. I think it would be something to the, again, I'm speculating here. I mean, it wasn't a long conversation because I knew that Dusty had, or Chief Bennett had been placed on administrative leave. So I knew that an investigation would be ensuing. So there really wasn't much to say. I mean, I kind of knew that it was going to happen. I didn't realize that I would become the investigator though, until I received the email.
Were you surprised when you got that email saying that you got appointed?
No, because I'd already had the conversation about my availability as to, and if I said yes, I was available, then one can logically assume that I may be the one.
And were you aware that this investigation was related to the levy issue or the fire department's levy issue?
No, I don't think it was related to the levy issue. The scope of the investigation was the unauthorized disclosure of attorney-client privileged information.
But the subject of the email that is purportedly attorney-client privilege, that had to do with the levy. Is that correct?
Correct. It had to do with, yes, it was pertaining to the whole levy situation, right, in general. Yeah, right.
And you had this wasn't your first experience related to the fire department levy, was it?
No, as I mentioned earlier, I had been, earlier this year, I worked with Dusty and probably another 8 or 10, I can't remember. I think it was 10 people total on the levy committee.
And so you were on the levy committee, and would you say that you were very active on that committee?
Yeah, very active.
Would you say you shared your experience and your opinions with the members of that committee?
I'm not sure about the experience part of it, but the opinions, I think everyone on the committee shared their opinions. I'm not sure what you mean by experience, but I mean, when I think of experience, like what I was just reading in my bio, I don't know that that's actually what you're talking about, though. So.
Okay. Well, I'm going to just hand you what's been marked Exhibit O or Respondent's Exhibit O. Can you just kind of take a look at that email?
Do you have a copy for the board?
We do. We'll give you this whole binder here.
Why don't you?
Because I'm looking.
All right.
Yeah. Why don't you give it to Kevin and you guys can share?
What are we looking at?
Exhibit O. So they're all tabbed. So if you want to go to O.
Did this come from the data that we
Yes.
sent to you?
Yes.
What's the date of the email and the sender and recipient?
It starts. Well, there's Steve's at the top. My paralegal's names are at the top because these are Outlook documents that had to get printed, right?
Okay.
But February 21st, 2024, from Sharon Warwick,
Okay.
RA Harlan FD Levy Committee. Mr. Williams, I'm not gonna ask you anything specific necessarily about that email. It's just to say, did you share your thoughts related to the amount and potentially the types of expenses that would be provided for as part of the levy?
Actually, I made a presentation. Would you like?
Yeah, I think.
Yeah, I made a presentation at one of the trustee meetings. I don't recall the month. Maybe it was March or April of this year. But I'll get back to that in just a minute. But yes, during what I had done was I had collected publicly available information from the auditor's website that contained all the property valuations and the assessments, and for all of the properties in Harlan Township. Built a spreadsheet, and that spreadsheet was a tool for the levy committee to use to essentially plug in different numbers. So if it's a 3 mil levy, it's a 3.5, 4, et cetera. And instantly it would tell you how much revenue would be gained by that, if that amount would be passed. We then took as part of that same spreadsheet, we had the fire department budget. So you can think of it very simplistically as, well, I have revenue coming in, I have expenses going out. So then we took the budget. And so then we went through an extensive exercise of, well, if I have this much coming in, what can we fund? How many people can we hire? How many fire suits, how much equipment, how much training, all of that. And as you can imagine, the higher the levy amount, the more you can fund, right? So yes, that was something that we discussed as a levy committee. The committee settled unanimously at a 3.5 mil levy. Then a presentation was made before the board. The board adopted that, and then the process began to move forward, to get that on the ballot.
As part of this committee, did you have any disagreements with Chief Vinna over funding the fire department and how much was needed?
Absolutely not. There were discussions. Everyone had different opinions about where they would like to see in terms of funding. And I think as a general consensus, again, it was unanimous. It wasn't just me, it was unanimous. Everyone voted 10-0 at a 3.5 mil. The reason that the committee settled on that was that would fund all of the paid on-call, paid part-time personnel. And it did not fund the replacement of vehicles like new fire trucks and new ambulances, et cetera. And it was agreed by the levy committee that those, the apparatus would be funded separately, as the need arises, because the township had just put a 5.7 mil levy on the ballot last November, and it had failed. So if we had tried to fund everything, we would have been right back up there at 5.7 mils, and it had just failed. So I believe that's why the committee decided that, the township has already stated, by their vote, that they did not have an appetite for 5.7. So we backed it off to the next thing. We prioritized what's most important: getting people and getting the training and getting the equipment, or getting the fire gear and stuff.
And I understand that the committee came to a unanimous vote, but in those discussions, you said there was differences of opinion. Did you have differences of opinion with Chief Vinna?
I can't literally state what Chief Vinna's position was. I know that he initially wanted to come in at an amount that would fund everything, all the vehicles and all the personnel. I'm not going to say that I had a disagreement. I know that this is not a public forum here, but I would.
Well, it is a public forum.
Well, not necessarily inviting comments. I was going to say, if anybody is here from the levy committee, please chime in, but they can't. I don't think there was a difference of an opinion on whether we should try to push for a 5 mil or a 3.5 or a 4 or a 2. that's part of the process that the levy committee needed to go through. That doesn't necessarily mean we had a disagreement. That just means we are going through the exercise of looking at option A, option B, option C, option D. So no, I would not classify that as a disagreement. I don't know that anyone on that committee had a disagreement with anything. They just had differences of opinions. Well, what about this? What about this? And we had to discuss priorities.
Do you have a personal friendship or any relationship outside of your duty as the investigator with any of the trustees or other township employees?
Yeah, I would say that have occasionally met with Mr. Shelton on a personal level. We are both Christians. We attend the same church, even though that we don't really see each other there that often. But I think that was a natural connection for us. And I would say otherwise, I mean, it's just the casual, if I bump into somebody around here, but there is an occasional phone call that Mark and I have on a personal level.
So you'd say you're friends?
You need to answer audibly. I'm
Yes,
sorry. She's
sorry.
recording. Yeah.
Yeah.
Mr. Williams, were you paid at all to conduct this investigation?
No.
Any promises of any favorable treatment or positions within the township?
No, this will probably be the last time this township sees me. I mean that seriously.
How many hours would you say you spent working on it?
I probably have every bit of 80 hours or more on this.
It's a lot of time if you're not getting compensated and sitting here, being questioned by me. What made you want to do it?
Well, what made me want to do it was my entire life I have spent in service with some cause. 20-year military career. I have family, a large family. I have 8 children. I have 10 grandchildren that I still serve to this day. I'm new to Harlan Township. I bought some property here a few years ago, started building my house last year, moved in this year, and I wanted to get to know my community, and I wanted to make an impact in some way. As far as this investigation, I had no idea that it would get to this point. So what inspired me or motivated me to do it was just the sense of service to try to make a difference in whatever way I can for the community.
So we'll talk a little bit more about the investigation here. So the investigation was, the initial scope, as you said, was about the disclosure of this email. And then it expanded, correct, as you started conducting your investigation. Is that right?
Correct.
Were there any allegations prior to starting your investigation that Chief Bennett misused township issued devices or resources?
Were there any allegations prior? No. If there were, they wouldn't have been discussed with me anyway. I mean,
so that wasn't the basis of the allegations upon which you were initially supposed to investigate, correct?
Correct.
Any allegations that he improperly deleted township records or data?
No, not initially. Those were all things that were discovered during the investigation.
Were there any allegations of potential criminal misconduct?
No.
Were you advised by the trustees or Ms. Horvath or someone from the prosecutor's office to provide any witnesses, including Chief Bennett, their what are called garrity rights?
Now, can you restate that? Was I advised by them to do what?
To give Chief Bennett what's called his garrity rights.
No.
Do you know what garrity rights are?
I've never heard that word. Can you explain it?
Well, I mean, if you can't explain
He's asking the question.
I'm asking the
Oh,
question.
okay.
Right. And I actually believe we did talk about this when you interviewed Chief Bennett during the interview back in October as well. So, So who advised you on how to conduct the investigation?
I relied on two sources. First was the Ohio Revised Code that describes it, and as you're probably aware, it's pretty broad. I spoke to Ms. Horvath, and she explained from a procedural standpoint about how to conduct the investigation. Again, from a procedural standpoint, not necessarily a content standpoint, similar to the way she's kind of doing it here now. But again, the initial scope of the investigation was related to the disclosure of the attorney-client privilege email. So it seemed to be on the surface a pretty succinct type of an investigation.
Seemed fairly narrow.
Certainly.
Now, did someone advise you, or did Ms. Horvath advise you that you could expand into other areas?
Yes, that anything that was discovered as part of the investigative process could be brought into the scope.
Did you talk with anybody else from the Warren County Prosecutor's Office during this investigation?
I do not think so, no.
Were you included in any discussions or correspondence between Ms. Horvath and the trustees during the investigation?
Any correspondence? Possibly. I don't recall.
Hand you what's been marked exhibits M and Q. You don't need to read the whole thing.
Okay.
But are those emails between you and Ms. Horvath where at least one of the trustees is also on the email?
Yes.
And are those related to the investigation?
Yes.
What dates are you looking at?
October 22nd, 2024. Email from Mr. Williams to you, Ms. Horvath, with Mr. Shelton, CC'd RE forward Dusty Binup. October 1st, 2024. Email from you, Ms. Horvath, to Mr. Williams with the trustees CC'd subject investigation.
Oh, they're the 21st.
We got the
Okay.
1st and the 22nd.
Oh, October.
Yeah.
Got it.
Now, Mr. Williams, did you believe you had an attorney-client relationship with Ms. Horvath?
No. Yes, she stated from the beginning that she was legal counsel for the township, not me.
Now, prior to finalizing the report, did any attorney or Ms. Horvath review it?
No.
Did you ever interview Ms. Horvath as a fact witness in your investigation?
I did not.
Okay, so you didn't ask her who her clients were in this case?
I don't know that I asked her, but during one of our conversations, she told me that she was counsel for the trustees.
Just the trustees?
Well, the board, or at Harlan Township, she's the counsel for the township, which I guess is represented by the trustees. I mean, there may be, that may fall, again, she would probably know this, or not me, but it could, I don't know if it's just the trustees, it could be any of the, I think it might be the actual officers as well, in their township capacity.
So you never answered that particular question as part of your investigation? Who Ms. Horvath's clients were?
I knew that it was the Harlan Township.
The whole township, everybody in this entire town?
No, not at all.
All right, explain. Who were her clients?
In this particular situation, it was the trustees.
The 3-member board of trustees that sitting before us.
To my knowledge, yes.
So,
What I was trying to suggest is beyond the scope of this investigation. As the prosecutor's office, they might have representation for other township officers, but that really was not part of this investigation.
so the email that purports to have, that Chief Vinup disclosed that was attorney-client privilege, who were the clients on that email?
The trustees,
Was Chief Vinup Ms. Horvath's client on that email?
I don't know.
You don't think that's an important question to answer as part of this investigation?
I don't know.
Now, I know you stated you don't have legal training, but are you aware that any communication between an attorney and their client, if it includes a non-client third party, is not protected by the attorney-client privilege?
It's my understanding, the way it was explained to me, that the email was attorney-client, it was designated as attorney-client privilege, and the only way to disclose that would be through the board. I believe that's why the board actually voted to disclose that to me for investigative purposes.
But this is actually a legal issue more than a factual issue. Would you agree with that?
Can you repeat the question?
Is this more of a legal issue or a factual issue?
Go back to the original question before that. Is what a legal issue?
Whether this email was actually attorney-client privilege.
I guess it is a legal issue. It stated attorney-client privilege on the subject line.
Well,
and I was told by the prosecutor, that the individual that sent it, that it is an attorney-client privilege email. So if there is a legal issue, I would suggest that you address that to another lawyer, because I don't know.
Okay, all right, that's a fair enough answer. So do you understand who holds the privilege over that email?
It's my understanding that the trustees hold the privilege over the client holds the privilege, which ultimately is the board of trustees.
And who can waive that privilege?
The client.
So in your report, you talk about 5 interviews that were conducted. Each of the trustees, Mr. Mason, the township administrator, and Chief Vinup, correct?
Correct.
Were all of those interviews recorded?
No.
Just Chief Vinup's?
Correct.
Did you take notes of any of those interviews?
I took notes with Mr. Mason and with Chief Vinup.
You didn't take notes on any interviews with the trustees themselves?
I did not, because they're the purpose of me speaking with them. I intentionally wanted to keep the conversation focused on the scope, and the scope was about the unauthorized disclosure of that email, and they were very short interviews because, again, my understanding was the way I was going to start this was I was going to meet with the trustees and essentially have them tell me in their own words, what is the scope? What specifically is it that you need me to investigate, that you're asking me to investigate? And I got that.
So this was less of a factual interview of the trustees and more taking direction on how to conduct the investigation?
No, not how to conduct it, but the scope of the investigation.
As part of your investigation, you asked for all of Chief Vinup's email addresses related to his position in the township. Is that right?
I asked for his email address. I don't think that's
access to his emails.
Correct.
Now, the allegation was that he disclosed information from Ms. Horvath in an email to the fire department, correct?
Correct.
And you had a copy of that email when you started your investigation?
Yeah, shortly after I was appointed as the investigator, right?
So if that was the initial allegation of misconduct, what was the purpose of requesting access to all of his other email addresses?
Yeah, the purpose was to see if there was a pattern.
What was that? Were you asked to investigate whether there was a pattern?
No. But
Why did you decide to do that?
I decided to do that because there were other things that came up that I called out in my report that gave me reason to question how forthcoming Chief Bennett was with me. And I felt that in order to prove or disprove, I would like to see more information. That's why I asked for it.
Were those things that came up that gave you those suspicions? Did they come up in the interviews with the trustees for which there's no notes?
No, I don't. No, they came up as the investigation unfolded.
But you only interviewed 5 people. Was that right?
Right, that's correct.
Yeah. And you didn't interview Chief Bennett until October, I believe it was 28th or so, correct?
Right, it was 28th.
But you asked for all of his emails before that, correct?
I did.
So what gave you suspicion that there might have been a pattern of?
I did say I had a suspicion of a pattern. I was curious if, because as the investigation was unfolding, I began to see delays. I began to see missing data, inconsistent, and I asked because, first of all, the township has a right to that if it's a township provided, and I asked for it because I was conducting an investigation.
So let's go off that.
And if you're going somewhere, if you're suggesting that I was just looking for dirt,
I'm not suggesting anything, Mr. Ryan.
Okay.
So you did say something though. You said that the township has a right to see those emails. Is that correct?
I believe that's in their employee handbook.
Well, it's also public records law under the Ohio Revised Code, correct? Are you aware of that?
Yeah, yes, it's public record, right?
So wouldn't the email that is the subject of this whole investigation be public records?
It should not be. Attorney-client privilege information should not be.
If it's actually attorney-client privilege, right?
I'll restate it. Attorney-client privilege information is not public record. And that's not the only thing that is a public record, right? There's personally identifiable information. There's other categories of information that cannot be released to the public. And so.
But if a document is not attorney-client privilege, not confidential law enforcement investigatory material, not public or PII, if it doesn't meet one of the exceptions, it's considered a public record.
Well, I think that would generally be a true statement, right? And everything that government entities do is generally public record unless there's an exception for it.
So moving through your report a little bit here, on your timeline of key events, you start with April 17th, when the trustees approved the 3.5 mil levy for 5 years on the November 2024 ballot, and it jumps to August 30th, when the incorrect ballot language is discovered. Is that correct?
Yes, that's the next timeline, right?
Okay. Based on your investigation, what you found, who was at fault for the incorrect language being sent to the Board of Elections?
I can gladly share it, but
could you state the relevance of that question?
Yeah, I'm just questioning the relevance of it.
I think it's relevant to what we're investigating here. It's the subject of this email is how to correct that language. And so, you've done a factual investigation. You looked at the incorrect language, the emails that were sent out. I'm just asking you, you've given your opinion throughout this report. I'm asking for your opinion on this particular subject.
You don't have to allow the
Yeah,
question.
that's-
You can note it, his
it's
objection
opinion.
for the
My
record.
objection for the record that that's a relevant question that needs to be answered. Did you review emails as part of your investigation that showed Chief Vinnup sent Ms. Horvath the correctly stated language that was voted on by the trustees?
Again, do you want me to, Mr.
Are you
Shaw?
objecting to the question or are you answering it?
I'm trying to get clarification as to whether or not this line of questioning is something that is relevant to this investigation.
Are you stating the email that was sent by Attorney Katie Horvath, the attorney-client privileged email? Is that-
No, I'm talking about a different email. In our book, it's Exhibit N. And I'll have you turn to, have to go down here, page 5 of that email. And that's an email from Chief Vinnup to Ms. Horvath. And in that email, it states the trustee selected a 3.5 mil levy for 5 years.
Answer the question, did you review the email or not?
Yeah, I saw the email. I just don't understand the relevance to this investigation. That's why I was.
Mr. Williams, you're a fact witness, so I'm asking you factual questions. Did you review that email?
I already answered, yes.
He answered.
Now, relevant to that line of questioning, did you you interviewed Mr. Mason as part of your investigation? Is that correct?
Correct.
All right. And did you ask Mr. Mason whose fault it was about the levy language?
Not at all. It's not part of the scope of this investigation.
Did he give you an answer related to that?
I don't recall that we discussed it. I mean, do you have the notes? Because I'm
gonna hand them to you. Here, it's Exhibit Z. Okay, great. Go ahead and look at the last G and H there. Can you go ahead? Can you read out loud for the record what note what 3H says?
What's the letter?
What is the letter?
Z?
It's Exhibit Z.
As in zebra?
Zulu.
Zebra. Yeah, Zulu.
So 3 hotel?
3 hotel. Correct.
This is a fire levy. The buck stops here. I screwed this up. This is my fault. I didn't catch the verbiage.
So that must have come up at some point during your conversation with Mr. Mason. Because you noted it.
Okay. If we were having a conversation and I noted it, I don't specifically recall asking that question though. I think if you look at that in context, there's, it's bullet point, bullet point, bullet point. There's several comments that were made that I was documenting. So to take 3H out of context is not accurate. If you look at all of them, I was merely almost doing a transcript of what was being stated. That does not imply that I was asking the questions.
But it came up in your discussion.
It clearly came up. I wrote it down.
Thank you. So let's go through your report some more. Turning to the key findings. So the first finding, unauthorized disclosure of privileged information. You find Chief Vinup repeatedly disclosed confidential information from an attorney-client privilege email without authorization. Do you understand the difference between attorney-client privileged and confidential?
As far as I understand it, attorney-client privilege is a form of confidential correspondence that is legally protected. That the attorney has an obligation to not disclose that. As you asked earlier, the client has the privilege of disclosing it or not. And in this case, the client is the board of trustees.
What's confidential?
Confidential is more of a, I would say, more of a generic term that could describe a whole various types of information. Just, it could be personally identifiable information, could be home addresses, phone numbers, various things like that could be confidential.
So confidential is much broader.
Right. Correct.
But in addition to being broader, it can be harder to determine what's confidential and what's not confidential. Would you agree with that?
Not when the email says attorney-client privilege on it, but yes, in general, you need to have classifications of. A best practice would be to have classifications for different document types with different handling procedures for those, whether it's confidential, whether public record, etc.
So, Mr. Williams, does putting in the subject line attorney-client privilege, does that make it an attorney-client privilege interpretation? Just putting it in the subject line.
Well, no, it's coming from the attorney themselves. So I think, right, I could create an email and put attorney-client privilege in there, and it's not.
And you send it to
whoever, right?
Your friend. No attorneys on the line, or even if there were attorneys on the line.
But when it's coming from the attorney, explicitly stating that it's attorney-client privilege, and it's sent to the trustees, then one would logically assume that that's attorney-client privilege information.
But you're not really. You don't have an understanding of the addition of non-client third parties to those emails, correct?
Again, if you're going to get into legal terms, I would suggest you talk.
I'm just asking if he has an understanding.
I think he's answered it several times.
So it's your understanding that on that email, Chief Vinup himself, or as the fire chief, was not Ms. Horvath's client, correct?
No, I'm not stating that. I'm stating that the Harlan Township trustees, and I believe it says, I'm not 100% certain, but I did read this. I just don't have the Ohio Revised Code in front of me, so I'm not going to state it as a 100% fact, but I believe it in the code, it says, and officers acting in their official capacity, which would include Chief Vinup.
So if Chief Vinup is a client, wouldn't he then have the ability to waive the privilege?
No, because
if he's a client himself?
He's not an individual. If, for example, if you send him an email that was attorney-client privilege, he could waive it as an individual, but he does not have that authority to waive it without authorization from the Board of Trustees.
And what authority states that?
I don't have that. I don't know.
So you saw the email that Chief Vinup sent to fire department personnel, correct?
Correct.
And it was your finding, based on interviews, looking at the email, that it was only sent to other other members of the Harlan Township Fire Department, correct?
As best I could tell.
So one of your findings here is that on September 25th, 2024, while on administrative leave, Chief Vinup forwarded a privileged email to a lawyer in Cincinnati. Is that correct?
Correct.
And you found that to be misconduct or a violation of the attorney-client privilege?
Correct.
And I hand you and ask the trustees to look at Exhibit CC Charlie. Do you recognize that letter from your investigation?
Yes, I
Did you read it as part of your investigation?
did I read it? Yes.
And what is that?
This is the letter that was sent to Chief Vinup advising him that he's being put on administrative leave.
Okay. And when's that dated?
The 20th of September.
Okay. I'm going to have you look at the second paragraph. I believe it's the second to last sentence. It begins with you on the fourth line. You see that?
Okay.
Can you read that out loud? That
You're-
sentence?
Yeah, you are not to disclose any details of the investigation to any party other than a personal legal representative.
Let me take that back. So that letter authorizes Chief Vinup to disclose information from this investigation to a personal legal representative, correct?
Yes. That's the way I would interpret it.
Would you say that sending that letter 5 days, or sending an email to a lawyer in Cincinnati 5 days after you received that letter is in line with the direction from the Board of Trustees?
Yes, I would.
So do you still consider number 2 to be a violation of the attorney-client privilege or misconduct?
No.
So you'd recommend to the board not to accept that finding?
That's that specific incident, correct?
So the next one, on October 15th, 2024, Chief Vinup forwarded the privileged email to his personal AOL account. Correct?
Correct.
Were you aware around that time that Chief Vinup was no longer going to have access to his township accounts around that time?
I had no idea.
So if Chief Vinup sent that email to his personal AOL account and then sent it to his attorneys, would it be a violation or would it be misconduct?
We're getting into this, but I don't know. I mean, the facts as I saw them was he forwarded to his AOL account. And in my discussions with you and him during the interview, it was stated that he had no township records. And that's why I singled this out. In addition to, it was attorney-client privilege, but it was also, there was evidence of him forwarding, a lot of township records to his personal account.
Is there does the policy say that he can't do that?
I do not know that if there is a policy that says that he cannot do that.
Is there a statute that says he can't do that?
Do not know. But that wasn't really the context of this. The context was it was a privileged email, and therefore my assumption is that it would be something that would not be forwarded. That it's under attorney-client privilege.
We talked a little bit about public records earlier. I know you've studied the revised code for this investigation and looked at different chapters. Are you familiar with revised code 149.43, which is the Ohio Public Record Statute?
No. I'm sure I've read it, but I wouldn't use the word study.
Okay. And we talked about this a little bit. You know, there are certain exceptions for, you know, against disclosing public records for confidential law enforcement investigatory records, other things like that. Would you consider these records at issue to be law enforcement records?
Law enforcement records? I don't think so.
Part of your investigation, did you find any evidence that either the trustees or the assistant prosecuting attorney explicitly told Chief Vinup not to disclose this information in that email to fire department employees?
Explicitly told him not to? No.
Moving on to the finding of deletion of potentially relevant data. So we talked previously about digital forensic examinations, and you said you were not trained to conduct those, correct?
Correct.
Yeah. So how did you come to the conclusion that these records were deleted?
So when you look at the web browsing history, for example, that was one of them. The web browsing history on the laptop was deleted. It said there was no history. So one can reasonably conclude one of two things. Either he never used that laptop for web browsing, or he deleted it. So since that was his primary laptop used to access, daily, perform his daily duties, it didn't stand to reason that he just didn't use it, right? He was the fire chief. So the assumption, the interpretation is that it was deleted. Same thing with the mobile phone. When you look at the call logs, they were deleted. In fact, I don't know that this is even in dispute. Dusty admitted during our interviews that he deleted it.
Did you look at the settings of either his email account or the phone to see if there's an auto delete function on or anything like that?
The settings on his phone, I am not aware of there being an auto delete function on a phone for.
You're not aware that you can have an auto delete function, or you didn't look and see if his phone had that?
Neither, because I was not aware that there is an auto delete function. If you're suggesting that there is, then that's new to me. An auto delete for what specific type of data? Anything, everything?
Messages, phone calls.
Don't believe that exists.
You don't.
If you have information to the contrary, I'll probably stand corrected.
Okay. So you don't have information that there were emails previously on there deleted, or there were websites visited that he deleted. This was all just based on your observation.
No, it was based on what I apologize. I interrupted you.
Yeah, go ahead, finish.
It was based on what Dusty said during our interview, that he deleted it. He attempted to wipe the phone. In fact, he used a word. He didn't use the word wipe. He used a different word. I'm sure it's on the recording. But it was something like, I want to say like blow it up, but that wasn't the word he used. But he was attempting to factory reset it and delete the data. I mean, he clearly stated that on during our interview.
Did you have any reason to believe that there was anything improper on either his phone or his emails, or he was visiting improper websites?
No, not at all. That's why I titled this potentially relevant data that was being deleted.
But you're saying potentially relevant data. You're not sure what that data was, correct?
Well, you can't be sure if you can't see it.
So what is the misconduct of deleting data that you're not sure of what it is?
The misconduct is deleting data during an investigation. It shows an intent of non-cooperation and not being fully transparent when you're deleting data. I think any reasonable person would agree that when you're under investigation and you start deleting data, that it's going to raise an eyebrow. There are also sections in the employee handbook that specifically talk about this, and it's not in my report, but I assumed at some point during this conversation that someone may ask, what specific policies were violated, and so I do have that information if you would like me to read it.
So you say Chief Vinup attempted or admitted to attempting to erase the phone before returning to the township to transfer data to a new device. Did he say erase or delete?
I don't have the transcript in front of me. He did not say erase. He did not say delete. He said another word that was, like I said, it was something like wiping it out, or he didn't use the word factory reset. I just don't recall the specific word, but it was a kind of an unusual word. He said it twice during the interview, and it is on the recording. But it was the equivalent of attempting to factory default it or wipe it clean.
And you say that the trash folder only had 5 emails. Did you look anywhere else besides the trash folder in that email account?
Yes.
Were there any other folders besides the trash that you reviewed that had emails in them?
That had emails in them?
Yes.
Yes. Yeah, there were a lot of folders. There was his inbox, and then there were additional folders that he had created that he was moving emails into. There's the sent items, So yeah, there's a lot of folders.
So it sounds like he had pretty good email management if he's putting it into different folders.
I can't draw that conclusion because, again, you're only seeing what you see. The question, the fact that we're debating right now is what you can't see. So I can't draw any conclusion based off of that. I stated the fact that the trash folder only had 5 days worth of email. And the TDS email retention policy, which I have printed off somewhere in here, is something like 30 days in the trash. So I do believe that was discussed during our interview as well.
Go ahead and move on to your finding that he exhibited multiple instances of non-cooperation and delay, titled it obstruction of the investigation. You state that he failed to respond in a timely manner. When did you first contact Chief Vinup and tell him that you were the investigator appointed by the board?
It was an email. Let me see if it's in the report here. I want to say it was, on October 4th, where I sent an email to everyone requesting emails and text messages from all township officials.
Did you reach out to Chief Vinup on October 4th?
I sent an email to everyone on October 4th, and Chief Vinup was on that email.
Okay. And you did not contact him to request an interview until a week later on October 11th. Is that right?
Correct.
So it states that he was directed to meet with an investigator on October 17th, correct?
Right. He was told on the 15th to meet with me on the 17th.
Okay. So on October 15th. I'm going to go ahead and point the trustee's directions to exhibit DD Delta Delta. I'm going to hand you the marked exhibit DD.
What's the date of that email?
It is October 16th. The top email is October 16th, 2024. And I'm going to actually ask you to turn to page 3. And it's an email from my colleague, Mr. Withrow, to you, Mr. Williams, on what's the date that Mr. Withrow sent you that email?
The 15th.
Okay. And so at that point, you understand that Chief Bennup's represented by counsel.
Yes, as of the time this email was sent.
And in that email, does Mr. Withrow ask to speak with you to discuss the investigation?
Yeah, I can read it if you like.
No, it's okay. It'll be in the record. Okay, and so the next email up in the chain, so if you turn to page 2, you can go ahead and read your response to that email on the 15th.
4:22 p.m.
Yes.
Mr. Withrow, thank you for reaching out. Please let me know what specifically you'd like to discuss or any questions you have for me. Unfortunately, I do not have time today, but I may be able to make time tomorrow if needed. Thank you.
So you didn't have time to speak with Mr. Withrow on the 15th, correct?
Right, it's 4:22 p.m.
Is that late in the day that you can't answer a phone call?
No. I have personal obligations. Would you like to see my calendar?
I don't need to see that, Mr. Williams.
You don't need to question why I can't talk to somebody. But anyway, do you want this passed?
I'll take that. So going back, so this is all occurring on October 15th. Wasn't that the day that you said Chief Binnup improperly forwarded that email to his personal AOL account?
Correct.
So if he sent that email from his personal AOL account to myself and Mr. Withrow, wouldn't that have been in line with the direction from the Board of Trustees that he could disclose information from this investigation of personal legal counsel?
I don't, you're drawing a conclusion there that isn't in the facts. He sent it to his AOL account. Why? You need to ask him. I don't know why he sent it to his
He'll
AOL.
have an opportunity to discuss that.
Yeah, I mean, he sent the other one directly to legal counsel. He did not send this one to legal counsel, even though your firm was his legal counsel on that day. So I don't know why he did it.
So number 2 on the list of under obstruction of investigation on October 15th, Chief Binnup was directed to meet with the investigator on October 17th, but he failed to do so. Correct? That's what you find. But this email from Mr. Withrow says, before we commit to having him meet with you, we need to speak with you first. Correct?
That's what it said. That doesn't necessarily mean that he can't meet with us, though. I mean, that's what his legal counsel says. And
So
honestly,
are you calling Mr. or Chief Binnup's actions and on advice of counsel, are you including that in the misconduct that you say he committed?
I do not know when he was actually advised to meet with me. I mean, I did not make that notification. It was someone from the trustee's office. As far as I know, they could have told him at 9 a.m. and I got this email at 3 or 4 o'clock in the afternoon. So I'm documenting the facts that he was instructed to meet and he failed to do so.
But you didn't include that legal counsel reached out to try to speak with you first.
That had nothing to do with Dusty. It wasn't obstruction of the investigation. This section is obstruction of the investigation.
But you're You know he's represented by counsel. Counsel has asked to speak with you before Chief Venup sits down for an interview. And you're calling that obstruction. Is that accurate?
What I'm calling obstruction is that he failed to meet with me. And to meet him when he was directed to do so.
So number 4, you state, after more than 4 weeks, Chief Venup submitted selective records, omitting messages with the Township Fiscal Officer, Jenny Williams, and Trustee Kevin Kern. Is that correct?
Correct.
You already had those records, correct?
Correct.
So were you trying to play gotcha with him?
No. Absolutely not. As I stated from the very beginning, I requested all records from everyone.
What were the records that he omitted?
I do not recall. They were random. They're in the evidence that I supplied. They're random messages pertaining to, like the one from Kevin may have been related. I think it was sometime around when he was being put on administrative leave. I think there may have been a message or two between he and Kevin on that topic. I think the topic between he and Jenny had something to do with either a trustee meeting or something to do with the levy. But again, they were not really, specific to this email or any of the other pertinent things. It was an inconsistency is why I noted it.
Your 5th finding there is that Chief Venup didn't provide any messages with fire department leadership, who would likely have discussed the key issue vital to their department, raises suspicion. Okay. Do you have any evidence that those emails existed?
No. And
so you're speculating that there should have been email.
I'm calling it into question that there was none. Because as the fire chief, and one can reasonably assume that the fire chief.
You say reasonably assume.
Let him answer the question.
One can reasonably assume that the fire chief, the head of the department, will have some sort of conversation with the officers of that fire department on matters concerning the department. We're talking about levies. We're talking about hiring people. We're talking about going from a all-volunteer department to a paid part-time department. There's all sorts of things that a fire chief would reasonably be speaking to his leadership about, and none of that was provided. So that's why I called it out. I have no evidence, and again, I can't prove what I didn't see.
So you say there should be emails from Chief Venup to the fire department related to fire department matters that are relevant to the department, correct?
One can reasonably assume that, yes.
Don't we have an email that Chief Venup sent to the members of the fire department talking about a levy that directly affects the fire department and its members?
Right, you have one.
Right. But that's misconduct because he sent that.
That one particular email that we are discussing is the one that is attorney-client privileged information.
So it's misconduct that he did send the email. It's also misconduct that he didn't send the email.
You can spin it however you want.
I'm just asking you.
That's not the way I see it.
I'm asking you for your findings on that.
That's not the way I see it. My findings, the report speaks for itself.
All right, we're moving to unauthorized actions here. Now, before you started looking at Chief Venup's accounts and determined he deleted information, there were no allegations. I'm sorry?
I apologize. I shouldn't have interrupted.
There weren't any allegations that he had deleted any information.
Correct.
Correct. But you believe you were authorized to investigate that?
I didn't specifically look for it. It was just there when as the evidence was unfolding, it was apparent that there were gaps. So I was not looking for it. It was just an apparent gap that arose throughout the investigation. Again, I mean, you can't go intentionally look for something that you may or may not even know exists. But when you see it here and then you don't see it there, then you know there's a gap.
Okay, we're gonna go ahead and move to the conclusion here. So you state that a preponderance of the evidence supports the conclusion.
Let me get that page. Yes, conclusion.
Yeah,
Okay.
conclusion. Preponderance of the evidence supports your 4 conclusions. What is preponderance of the evidence?
That is a lower standard than, beyond a reasonable doubt. I'm sure I'm not gonna give you the legal definition of preponderance of the evidence, but I chose those words intentionally because as I was doing my research to prepare this, that's the evidentiary standard that I applied. And the preponderance is in consideration of the facts that I had seen and applying a reasonableness standard to it. What would be typically expected of an individual in this capacity. The preponderance of the evidence supports, meaning that I have more evidence than not to support this.
So, I mean, that is a legal determination.
I'm sure it is. Yeah, I remember reading it.
So you state at the end, after your 4 conclusions, that these actions constitute serious breaches of professional conduct. What's that based on?
Knowingly disclosing attorney-client privileged information.
I'm not asking you to reread the conclusions. What is?
He's answering the question.
Again, the preponderance of the evidence, professional. Are you asking me?
I'm asking you, what is professional conduct that he breached?
Knowingly disclosing attorney-client privileged information, deliberately deleting data, misusing township resources. That's a breach of professional conduct.
But is that in some kind of a standard, or is that your own subjective opinion of what professional conduct is?
That is a preponderance of the evidence that supports that.
Okay, moving lastly to your recommendations. You recommend the board consider taking actions in line with Revised Code 733.35 for misconduct in office and malfeasance. How are you defining the terms misconduct and malfeasance?
The misconduct is clear. As I correlated it, is those 4 items above in the conclusion. Misconduct and malfeasance is not doing what you need to be doing. I know that's not the legal definition of it, but they go hand in hand.
But the legal definition is what's in the statute, or it's a legal term in a statute.
Right.
So there should be a legal definition for it.
There is, and I read it, and that's why I came up with that word instead of nonfeasance or misfeasance. I just don't recall it off the top of my head.
Your second recommendation, review and strengthen policies regarding confidentiality, record management, township resources. Do those policies already exist?
Yes.
All regarding confidentiality?
I don't know if those exist.
You don't know if they exist?
Yeah, the confidentiality.
So you don't know if Chief Bennett violated any policy?
Well, I do know that he violated policies. I have
related to confidentiality.
I have I have 2 pages here. I have specific policies for each of those 4 allegations that I believe were violated. So the answer is yes. Now, is there a specific confidentiality policy? I don't recall seeing one.
Your third one is to implement mandatory training, which I agree is good. But that doesn't already exist, is that correct?
I do not know.
You didn't ask as part of your investigation?
No,
whether
that was something that I was trying to button this thing up.
And your last recommendation is to consult with legal counsel on the following revised code statutes. Revised code 29.2112, tampering with evidence. Revised code 29.1304, unauthorized use of property. Are you aware those are both criminal statutes?
I am, and that's why I said consult with legal counsel. That's not a recommendation that I'm making.
It's under recommendation.
Well, I was not recommending that they take any action. I was recommending that they consult with legal counsel.
But this was,
for applicability.
you stated that this was not a criminal investigation, correct?
Correct.
And you did not read Chief Vinup his Garrity rights prior to interviewing him, correct?
Right.
But the evidence that you elicited from your including from your interview with Chief Vinup, would you say that goes towards your recommendation there? On number 4, related to those statutes?
No.
I have no further questions at this time.
I'm gonna recommend to the board that you give Mr. Williams a break. And while you kind of think about what you want to ask him in response. Follow-up questions.
Does anybody need a short recess?
I don't.
You don't? If you need to go back, you're nodding your head. Make some noise. Go ahead for a minute.
You want to say 10 minutes? 5 minutes? 5?
We'll take a 5-minute break.
All right, so everybody's just real quick in here. So when I do these videos, everybody knows I turn the sound off. I leave the video run. That way there's current video running. So I will turn the sound off right.
I know.
All right, we're gonna continue the hearing. Everybody present, you just. Next.
So,
Okay.
I would say you should, if you, the board has any questions for, Mr. Williams based on the questions that were asked of him, by the Chiefs Council, you should ask those now and get clarifications that you would like.
Mr. Williams, you stated, you didn't have the info, as far as township officers falling under the trustees legal counsel. Where would you find that information?
I remember reading it in the Ohio Revised Code.
RC?
Yes, I don't recall the specific number.
And then early on in the investigation, the levy committee was brought up and about disagreements, people, the members all having their own input. Do you ever recall any arguments between any levy committee members?
No.
Everybody was respectful.
I would not refer to any of the conversations as disagreements. I would refer to them as different opinions on where we should start, but we clearly unanimously ended up all at the same place at 3.5 mils.
Okay. And then, was this investigation a criminal investigation?
No.
The Garrity rights only pertain to criminal investigations. So you're clear on that. So there was no reason for you to read him.
Okay.
Rights.
Thank you.
Am I correct on it? Am I correct on that?
Yeah, it's just not really a question.
I just wanted to explain that to him. My question was it a criminal investigation?
No.
You guys have any questions for the investigator?
I do.
None? No.
Can I make a recommendation?
Yes.
I would recommend, you mentioned a number of documents. I would recommend asking him, if he wants to admit some of those documents, such as the HAMP that he talked about and the policy violations that he talked about.
Do you have
The handbook is the township employee handbook that I didn't think about entering that, but that there are clear violations or from the handbook. So I kind of assumed that, that was part of this.
Do you have an objection to the handbook being marked as an exhibit?
No. Okay. Need a copy right now.
I have a copy, but I'm not. What are we on?
And there's the
You have a copy of the handbook?
We've received it. I don't have a copy in front of me, but okay. We'll stipulate to that.
Meaning that this is the handbook. Do you want to see it?
I'm fine. Here's a copy. Katie, what number is that?
5. You mentioned another document, something that you have in front of you. I would recommend asking him about that.
Yeah, this document.
What other document do you have, Mr. Williams?
I prepared this in advance because I wanted to be ready for someone to maybe ask me if, what policies were violated, right? The report has several conclusions that I drew, but I did not specifically in the report. I did not specifically mention the specific policies that were violated. So
is this the question that Dusty's legal counsel asked you about the policies earlier?
He may have asked. I remember him asking a policy about confidentiality, and I said I don't know about that.
Okay.
Whether there's a policy.
Could you clarify?
But what this is there were 4 specific findings. One was the unauthorized disclosure of confidential information. I believe that in the township's public records policy on page 1, it states that all exemptions to openness are to be construed in their narrowest sense. And any denial of public records in response to a valid request must be accompanied by an explanation, right? So I believe that that's relevant here, is that policy is relevant because the chief's disclosure of the attorney-client privilege information violates the duty to protect records that are exempt from public disclosure. So that's the first violation. The second one is under the deletion of potentially relevant data. That was one of the other findings. In the employee handbook, section 11.2.6, it lists group 3 offenses. So let me define, this is straight out of the handbook, and I'll quote: the group 3 offense is a wanton or willful neglect in the performance of an assigned duty or in the care, use, or custody of township property or equipment, abuse or deliberate destruction in any manner of township property, tools, equipment, or the property of employees. The handbook also states that a group 3 offense is stealing or similar conduct, including destroying, damaging, or concealing any property of the township or other employees. Then in section 11.2.8 of the handbook, it explains that a group 3 offense involves moral turpitude, which is an act or behavior that is contrary to accepted community standards or violates a person's duties to others. And it reads in section 11.2.8, it says, offenses set forth in group 3 involve moral turpitude or other conduct which may reflect adversely on the township or otherwise adversely on one's ability to function effectively as a township employee due to lack of public confidence. Now, I believe that's relevant because the chief's deliberate deletion of data of township-owned digital records during an active investigation would be considered destruction of township property and is a group 3 offense. The handbook further states that group 3 offenses may be terminable upon the first offense as determined by the trustees. So number 3, the obstruction of the investigation in the handbook page of, or section 11.2, again, it's talking about the group offenses. The handbook lists this offense as the failure to cooperate with other employees as required by job duties. So the selective and incomplete cooperation breaches the requirement to cooperate fully. And also in section 10.8 of the handbook, which is the network and internet policy, it states, and I quote, all technology provided by Harlan Township, including computer systems, communication networks, organization-related work records, and other information stored electronically is the property of the organization and not the employee. In general, use of the organization's technology systems and electronic communications should be work-related and not for personal convenience. And then in section 10.8.8, it says email and other electronic communications transmitted by Harlan Township equipment, systems, and networks are not private or confidential, and they are the property of the organization. Therefore, Harlan Township reserves the right to examine, monitor, and regulate email and other electronic communication. I believe this is relevant because the chief's delays in responding, not complying with township directives to meet, deleting data from his laptop and mobile phone, and the lack of full transparency breach these sections of the handbook. And then the last one is the misuse of township resources. Section 11.2 again defines the offense as unauthorized use of township property or equipment. So this is relevant because transferring township resources to personal use without authorization. That was when Dusty had transferred, Chief Bennett had transferred his number and his data to a personal device without authorization. And then finally, in the fire chief's job description under essential functions, it says that the fire chief shall enforce the rules, regulations, policies, and procedures of the Harlan Township Fire and Rescue to ensure proper personnel management. And I believe that's relevant because the misuse of township resources contradicts the fire chief's duty to uphold township policies. So those are the violations in the specific policies that I think correlate to the investigation.
Do you need those?
Pardon
Or
me?
that was all part of the handbook, everything you just read, right?
Well, one of them was the public records policy on page 1, and then the last one was the chief's job description under essential functions, but everything else was
In the handbook.
in the handbook under 11.2 or a subsection of 11.2.
We need to have those as exhibits also.
The handbook's already admitted.
I mean, the policy.
The
Public
public
records.
records policy, I think I accidentally handed it to you with the handbook. I had all my policies in one stack. But let's separate that. We need to separate this. Is that okay if we separate those? Make one. Well, we'll find the, let's look there now. All right, we need to find the, public records policy, if you want to make that a exhibit, and the
Chief's job description was the other.
job description,
Yes.
record retention schedule?
No.
No?
No.
You guys have a copy of the chief's job description?
We have one.
I'm marking the copy of the job description. I think you have one in draft form and you have one signed by trustee Curran that indicates the employee did not sign. That's the one I'm marking.
Yeah, we have that one.
Okay. So we'll do the public records policy as 6. And the position description as 7. Okay. Any other questions from the board for Mr. Williams?
None.
Okay. You don't have anything else? Is Mr. Williams free to leave if he'd like to leave? Or would you like him to stick around in case you have additional questions for him? Either side.
He's not part of, we don't intend to call him as part of our case, so we don't have an objection to that.
All right, you guys have any other questions for the investigator?
No.
You want him to stick around in case you need clarification on something? Let's have him stay, if you don't mind.
We'll try to make it quick.
Right.
Everybody wants to get out here.
All right, so are there other witnesses that the board wants to hear from? That'll be your next. Whoever you decide you want more clarification on any issue from, or there's something that you heard from Mr. Williams that you want to get more information about, and you think that there's somebody who can give you more information about that, whether it's another township employee or whatever.
I do want to hear more about this cell phone stuff, but would that be Dusty? I mean,
If your questions are for the chief, then you can ask, I think he plans to testify, is that correct? So
So we can just
you can ask him then.
ask them now. Okay. All right, does the chief have anything he would like to present in response and within the scope of the investigation?
Yes, Mr. Shelton, we intend to call, a few witnesses. At first, want to put on the record and confirm, we requested subpoenas of several witnesses, or that the board subpoena several witnesses. One of them was, Ms. Horvath to testify. I received a response from, Assistant Prosecutor Nice at the Warren County Prosecutor's Office that she would not be testifying, and that they would not issue her a subpoena. So I object to Ms. Horvath not testifying in this case. She's a necessary fact witness. She drafted the levy language at issue and admitted that she did not see the levy should have been for 5 years, not continuous. That was sent to the Board of Elections. She sent the email to the trustees, and she VINUP that was purportedly confidential and attorney-client privilege. We believe if she were to testify, she would testify as to who her clients are, who the email was intended to be sent to, whether it was legal advice, and all of that is directly relevant to whether the communication was privileged, and whether Chief VINUP violated that privilege. There are also several communications from Ms. Horvath that were turned over as part of the subpoena and were public records request that only she can explain and give proper context to. So we object to her not testifying. Failure to produce her for testimony violates Chief VINUP's right to due process.
Her objection is noted.
Can I make a response on the record?
Yes.
Related to myself being subpoenaed? My office's position on that is that I am not a necessary witness. An attorney for the board is allowed to give legal advice to the board without converting into a witness. And there is no information that you can get from me that is either contested, for one thing. All of the documents speak for themselves, and there's nothing that you can't get from another witness or that is even a contested issue in this case. So your objection's noted for the
we do have other witnesses. While Ms. Horvath informed me that the trustees were not going to subpoena themselves, she did say that you would be available for questioning as part of this. So I would like to call you, Mr. Shelton, as our first witness.
I need to be sworn in.
yes.
I think you want to swear me in.
Or one of the other trustees.
You want to swear me in. Okay, that's 3 seconds.
Have him raise his right hand.
Raise your right hand. So,
Yeah.
I gotta find it. There it is.
raise your right hand, please, Mr. Shelton. Do you swear or affirm that the testimony you're about to give in this proceeding today is the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Shelton, we've never spoken before, is that right?
That's correct.
And it's the first time we're meeting?
Yes.
All right. So forgive me if I ask questions that, probably everybody in this room or this township I know already, but it just helps me to understand a little bit. Can you just give us a little bit about your educational and professional background?
High school, some college. 15 years here as a township trustee, served on different committees in the county. Also served on different committees here in the township.
Is your role on the trustees, is that your full-time job?
No.
What's your full-time?
Work for a railroad.
Do you have any legal training?
No.
Law enforcement training?
No.
And I think you stated this, you've been on the town, board of trustees for 15 years, is that correct?
Yeah, something like that.
So I'll just kind of jump right into some of the issues that were explored with Mr. Williams. Does the board of trustees have its own legal counsel?
Yes, well, we rely on the Howard County Prosecutor's Office.
So the Warren County Prosecutor's Office is your, I believe, statutory legal counsel?
Yeah.
Under the law? You don't have a township solicitor or anything like that? And who serves as your point of contact with the prosecutor's office?
This is Katie Horvath.
And how long has she served in that role with the township? Estimate, roughly.
I know for at least the past like 3 or 4 years.
And she's assigned to be your legal counsel from the prosecutor's office, but it's the office as a whole that represents the township. Is that accurate? Have you ever worked with any other assistant prosecutors or the prosecutor himself?
Just like when she's on vacation, if we have a question, somebody else in the office will take care of it.
So there have been situations where other prosecutors have stepped in to fill a role when she hasn't been available.
Not really just to answer a question.
But the statute, I assume, says that the Warren County Prosecutor's Office, not Ms. Horvath individually, is your legal counsel.
That is correct, but I believe they assign different people in the office to different townships and villages.
Are you allowed to discuss township legal matters with Ms. Horvath by yourself, or do the other trustees have to be involved in those discussions?
No, we should all be involved.
So as part of that representation by the prosecutor's office, who do they represent? Who is their client?
Carlin Township, the board, I believe, trustees, I believe the fiscal officer, the township, any of the officers, administrator, and the fire. We only have the administrator and fire chief.
Okay. So they represent, your statement is that they represent the fire chief as well, not just the board of trustees.
That's the way I've always understood it, yes. And he's always been included in the emails because he handles a lot of the like ballot language or any kind of other issues that might come up with the fire department.
Are you aware of any statutory authority or document that lays out who the prosecutor's office's client is related to the township?
I believe it's in the ORC.
Now, specifically, does the prosecutor's office work with the departments individually? And I know there aren't many, but do they work with them individually, or do they always communicate direct through the board of trustees?
Not sure how to answer that. I mean, as far as legal counsel, I mean, I'm not sure how Chief Bennett does like the ballot language. I believe he goes, does he go? I don't know how it all works. He usually handles that stuff.
All right. Now, I know you stated you don't have legal training, but what's your understanding of what the attorney-client privilege is?
Just that attorney-client privilege information.
But what does that mean exactly? Who holds that privilege?
Who's she sending the email to?
Would
Is that your question?
Yes.
I mean, yeah.
Yeah, well, does the attorney own the privilege, or does the client own the privilege?
I believe the client holds it. Once it's sent to us, I believe the client holds the privilege.
And it's not just emails, correct? It could be phone conversations or in-person meetings. Any legal advice you receive from your attorney, if they're giving you legal advice, it's attorney-client privilege, correct? So if the client holds the privilege, who can waive that privilege?
The client. Well, in this situation, the board has to waive that.
Now, when you state the board has to waive the privilege, what authority, either statutory or any legal authority, says that the board has to waive the privilege?
I'm just gonna object because he's not a lawyer, and
It
if
is
you're
a lawyer.
asking for his legal opinion or something that he's been told by a lawyer, he can't testify about that either.
Well, my response is, I'm asking for his lay opinion on what this means. The attorney-client privilege is directly relevant to this matter.
That's fine, but you asked him what the legal authority is that he's relying on, so ask him what his lay understanding is. If
Well,
If
when
that's
I,
what you're
when I
asking
ask for
for.
legal authority, it's, is there a statute that you're reviewed? Is there some document or policy that you're reviewed? Is that fair?
can answer.
I did. It was I said ORC, the Ohio Revised Code.
Can I see, exhibit 1, the email?
Yes.
Just wanna make sure we have the same. Oh, wait, no, that's the report. I'm sorry. What was our email? Was it
Which email?
the email, the attorney-client privilege label
One I
email?
sent.
Yes.
Two, I
Handed to you.
This is a version forwarded from Trustee Shelton to the investigator. Different version.
No, I think this. I apologize if I'm gonna stand up here just because I
No,
only
you're
have this
fine.
one copy. I'm gonna hand you what's been marked Exhibit 4 and just kind of flip through those pages. And you don't have to read it, spend time reading it, but from its face, do you recognize that document?
Yes. Yeah, that's an email question.
Okay, that's the email in question. And who is on the 2 line of that email?
At the top?
Yes,
Right
who
here.
is it addressed to?
To Frank Williams.
Well, I'm sorry, not that one, but the actual email that was in question itself.
It is to trustees Shelton, Administrator Mason, trustee Brzezinski, trustee Kern, fiscal officer Jenny Williams, and Chief Bennett.
And that's the email in question where Ms. Horvath gave the trustees the options for the levy language, correct?
Yes.
Okay. Go ahead and turn the page back. One. Now, there were other emails as part of that thread, correct?
Yes.
Prior emails from Ms. Horvath to the trustees?
Hold on, I'm not there yet.
Sorry.
Okay, I'm sorry, what was your question?
There were prior emails in that thread before Ms. Horvath sent the email with the options, correct?
It may have been a different email or something, I don't know. Is it in there? I didn't see anything.
So. It's hard to see because there's a staple at the top here, but there's an email there and it's, I put through the date on it, but it's titled minutes, correct? The very top there?
Yes. I can't see the date either.
Okay, that's fine. Can you take a look at that and see, is Chief Bennett on that email thread?
No, he is not.
Okay, so he was not on the prior email thread that was sent to the trustee. Correct.
Prior email thread.
Prior to the email with the option. He's not on that email that I'm showing you right now.
No, he's not. But like I said, I can't see the date.
That's fine. It's small. I'll take it back. Thank you. So at some point, Ms. Horvath added Chief Bennett to the email with the option, correct?
Now look at it again while he's asking you this question.
I don't recall, so I'm gonna have to pull this apart and see the date. That's all right.
Nope, that's fine.
Dated 11/20/24.
That's probably not the right date, considering this email thread happened, I believe, in
It's
August.
dated 11. Here, you want to look at it?
Yes.
11. It's
It's okay.
dated November of 24.
Well, today. Today.
That's the date. Just go ahead and read that whole line right there. Who it's to?
Marcus Shelton, Steve Mason, Ed Pergenti, Kevin Kern, Jenny Williams.
So Chief Bennett is not on that email.
No.
And that email is titled Minutes Attorney-Client Privilege Communication.
Yes.
Thank you. And that's well, I guess I should have handed it back to you, but do you recall that email saying that the content should not be sent to anyone outside the group?
Attorney-client privileged information. And at the bottom of it, there is a disclaimer stating it's not to be forwarded.
I'm going to hand you what's been marked Exhibit A, Alpha. It's just another copy of the email. It's just ours that we brought.
Which is yours, like, this is not a great copy. Just
Well,
because of the Gmail messes it up. What are you getting at? The signature line?
well, it's the confidentiality marker at the bottom. Handing you what's been marked Exhibit A, turning to the third page. No, small print, and I apologize, but if you can read that line, you don't have to read it out loud. Just read it to yourself. Let me know when you're done. Does that say anything about not forwarding the information?
Not, it's not meant for anybody that other than the addressees on the email.
But it says that it's not intended for use, or it's intended for use only by the individual or entity to which it's addressed. Is that accurate?
Yes.
Okay, so if somebody sends you an email, and you can use it for your own intended use under that designation. Does that make sense?
It's not, it says it's not to be sent.
It
Is that
doesn't,
what- is that
it
what-
doesn't say that.
Uh,
It doesn't say it's not to be sent.
Let me see that.
It says this email message is intended for use only by the individual or entity to which it's addressed. Got it.
Read
Okay.
the entire thing.
This message may contain information that is confidential or privileged. It is not intended for transmission to or receipt by anyone other than the named addressee. If you receive this message transmission and are not at the addressee, there is a mistake or transmission error. You must delete it from your system without copying or forwarding it. Please notify the sender or error by replying.
Right.
But it does say that the individual, the very first line says the individual to which it's addressed can use it. Correct?
Yeah, it was sent to them.
So, and again, this is why we asked to call Ms. Horvath to explain the signature block, but does that confidentiality marker show up on every email she sends?
Yes.
So, and it doesn't necessarily say that it is a confidential communication, it's just that it may be. Correct?
Yeah. I
So if
guess.
she sends an email to, you know, a friend, right, from her work email, it's not intended to be attorney-client privileged. It's not intended to be confidential. It just might be because she's sending that email.
Well, if it's legal, then it's definitely confidential. Or if it's marked confidential in the title subject line, we know it's confidential. And it can only be made a public record if we waive that right.
Well, you can waive privilege, but you don't necessarily waive confidentiality.
Another question?
I'm not sure what you mean by
Or
that.
do you know whether you can waive both privilege and confidentiality?
I don't know how to answer that one.
If you don't know how to answer that one,
I don't
that's
know how to
fine.
answer that
That's-
one. I'm
that's
sorry.
fine. That's fine. Okay. Outside of that line, were there any verbal directions from you or any of the trustees not to share that email with anyone else?
No. Self-explanatory right at the top of the email.
Would you agree that any email that is not privileged, attorney-client privilege, that is used for township business would be a public record?
Yes, as long as it's not marked confidential, if it doesn't contain legal matters.
Legal advice from
Yes.
an attorney.
Correct.
What was the legal advice that was sent in that email?
The options with the, there was concern over lawsuits. So that was kind of the basis of that being confidential legal information.
But there were three options, I believe or four, or is there three options that she gave?
4 or 5, I believe.
Okay. And as far as you know, does the township have a policy prohibiting disclosing attorney-client privilege or confidential material?
Township itself,
Township itself.
unless it's in our employee handbook, I'm not sure.
How did you find out that Chief Vinup shared the contents of the email with members of the fire department?
Through a resident that pretty much gave the wording word for word and said it came from a fire department member.
What was your reaction to that resident finding out that information?
My first reaction was,
Yours.
how did they get it? How did this, that was confidential information, so how did it get out there?
Did you know who disclosed that information when that person called you?
No.
Did you suspect how they might have gotten that information?
No.
Okay, so how did you find out that Chief Vinup was the one who shared that information?
I was given an email, a copy of the email.
And once you saw the email that Chief Vinup sent out, how did you feel then?
Betrayed.
Why?
Because it's confidential legal information, and I thought we had a professional organization here.
So what was unprofessional about him sending an email to department members about the options that the trustees had regarding the levy?
there should have been discussion with the trustees. There might have been, actually, I think we did request to meet. Well, no, he wasn't here at that meeting that night, so we couldn't meet with him.
Now, there's an underlying issue here of the improper language placed on the ballot, correct?
Right.
And that improper language was that the levy was supposed to be continuous instead of 5 years.
Right.
Correct. How did that language make it onto the ballot?
There are 3 processes.
And who was involved in those processes?
The Warren County Prosecutor's Office, the chief. Not sure, does the auditor's office have, I'm not sure if the auditor's office has anything to do with that, and the trustees.
Okay. So the trustees voted through a resolution to place that language on the ballot.
Yes.
And did you read it before you voted to place it on the ballot?
No.
You didn't read what you voted
No.
on?
It was handed to us in a meeting. We rely on the chief. We've always relied on the chief to handle the ballot language, to go work with the prosecutor's office, the auditor's office. So, yeah, there was 3 lines of failure, and we fixed that with a 7-day review period for any future ballot language. That trustees have to have the ballot language for 7 days before we approve it. Because we're shutting the meeting down for 10 or 15 minutes while we read 3 pages of documents. And we just have dead air while people are watching,
So you said it was 3 pages long?
There was 3 documents in front of us, and he needed the language approved.
So is it safe to say that you, at least in part, blame Chief Bennett for that language, that incorrect language being on the ballot?
Like I said, there were 3 failures.
But he's one of them that
Yes.
you feel he's one of them.
We're all, yeah.
Trustees included.
Yes.
You agree that you should read anything you're voting on a resolution?
That's why we fixed the issue with a 7-day review period before we approve it. We can't rely on things being done. Because we're all held to follow.
And you said the prosecutor's office was involved too.
Yes,
Correct.
they do the ballot language.
They actually draft the ballot language.
Yes.
Correct. Chief Bennett doesn't draft the ballot language. Is that right?
No, he takes it. Well, he gives them the information. They draft it. He gets it, approves it, brings it to us. We approve it. That's how it's done.
Did you see an email where Chief Bennett told Ms. Horvath that the levy should have been for 3.5 mil over a 5-year period?
Yes.
You did see that. So he did tell her the proper
Yes.
language. And then she drafted it, correct?
Yes.
And later in email, she admits that she missed that language.
Yes.
Correct. So she missed that language, and the proposed language she sent back had that continuous term in it, correct? All right. So when you found out that the wrong language was on there, what did you do?
I contacted Administrator Mason because I didn't think I was reading it correctly. Yeah.
Did you talk with the other trustees?
No.
About it? No, you never talked to them?
Not at that point. No.
Do you remember about what time, when you found out that it was wrong?
It was too late to get it off the ballot, or to get it fixed. It was around the end of August.
You recall texting trustee Curran about the language, the wrong language getting on the ballot?
No.
You don't recall that?
I'm just gonna ask what this has to do with the charges in the investigation against the chief, because we're getting into historical issues that I don't think are really relevant to the charges.
It's going towards potential bias of members that are potentially going to decide what happens to Chief Innup in this proceeding.
So
Due to the ballot language? That's not what the charges are.
Related to bias, which is a category or a subject that I can explore related to any witness, and especially potential or witnesses and officers that are going to decide this proceeding.
Marcus, you can't rule on this, but do you two want to hear any more about this issue?
I don't see it relevant. What I'll say is if we can't ask the questions of Marcus, we're gonna call the other two to see if they remember these things.
Because this text message is biased?
These text messages show that Mr. Shelton initially said that everybody was to blame, and then in a later text message said that only Chief Innup was to blame.
But that's not what these charges are about. He wasn't disciplined over that.
Well, what I'm still trying to show is that there's a bias, a potential bias, at least related to Chief Innup, that potentially would disqualify Mr. Shelton from making a decision in this matter.
Okay, do you want to note that that is his position on that issue? Allow him to admit whatever documents he has about that? Or allow him to continue to ask trustee Shelton if he's biased?
Okay. I don't see how this is connected or related. I don't feel that it's connected or related. But if you want to proceed.
Well, are you gonna let me proceed or not? That's the question.
How many more questions do you have left?
Look, I can be here all night. I mean,
Well,
as long as
that's
questions,
what I'm worried
as long as
about.
there's questions to
I
have.
mean, let's get this, I mean, we get what you're trying to say, so ask him a couple more questions about it. If there's documents you want to have in that you think demonstrate bias, I'd say allow him to do that. And then let's move on back to something that's relevant to the charges.
Tell you what, I will. You have in front of you exhibits R and S, which are these two text messages that were part of the investigation, received as part of the investigation. Between Mr. Shelton and the other two trustees. We will move to admit those for the record. And, you know, I don't feel the need to question anymore.
These are the ones between trustee Curran.
Yeah, there's emails, the first page is an email.
Yep.
Of R. It says, it's to Mr. Williams from Mr. Shelton, sent on October 4th, investigation text with Kevin.
Okay,
That's R.
got it.
And then S is same to Mr. Williams, investigation text with Steve. I'm sorry, that was to Steve, not Mr. Poganski. It was in the township administrator, Mr. Mason.
Got it, thank you.
Okay.
And that's S, you said?
Yes. Move on. Mr. Shelton, did you believe that by sending the email to the fire department, Chief Vinup committed insubordination?
I don't think I would. At first, I thought it might have been insubordination, but I don't think it goes under that category.
Do you recall sending an email to Ms. Horvath on September 17th of this year, in which you state, among other things, and I'll admit the whole thing, this falls on the chief not doing his job and or blatantly lying to us. This is insubordination. Do you recall sending that email?
Yes.
You recall receiving an email back from Ms. Horvath on September 18th, related to a number of options related to how to handle the situation.
Yes.
Okay. You recall Ms. Horvath saying, factually, you have a difficult case for insubordination.
Yes. She stated it did not fall under that. That's fine.
Do you recall her saying, you might have more success if the chief is charged with a breach of confidentiality? However, that is a complicated case as well.
I don't recall the whole email, but yeah, I know there were some options listed in that.
Do you recall her making recommendations if you decided to open an investigation?
Yes.
Do you recall her recommending, or she says, my recommendation is usually to support to appoint a private attorney as your private citizen investigator?
Yes.
That is because they understand how to write charges and how to conduct a fair investigation.
Yes.
She later says the law does not require an attorney, and if you have some other private citizen in mind who could conduct a fair investigation and articulate appropriate charges, township could ask that person to investigate them.
Yes.
Should you choose to appoint a non-attorney private citizen to investigate, I highly recommend you choose someone with investigative experience.
Yes. There was another option in there.
I'll show you the email. You can just tell me if
I'm correct. That's
show you what's been marked Exhibit T.
What's the date of that one?
October 9th.
Yes.
Yes. After the four options, the one we chose to go with was to speak with the chief directly about what was going on. And I believe his message was he could not make that meeting either. It had worked. I think I reached out by text message directly to him, requesting him to be at the meeting that night. Because that was going to be I think the third meeting that we didn't get a chance to speak with him.
Did you ever talk to, I know you have to do certain things in open session, but do you ever communicate directly with Chief Vinup on a day-to-day basis related to his duties as a fire chief? Phone, text, email?
Yes.
All three?
Probably mainly phone and text, maybe email. I don't know, might be an email here and there.
Are all those emails and or phone calls done on township devices?
As far as I know, his are.
Yours?
No.
So you send him work-related emails from your personal phone?
Yes.
And or text messages?
On my township account.
Okay, from your phone, but on your township email account?
Yes.
And you have a separate township phone number too?
No.
So, did you advocate for the board to place Chief Vinup on administrative leave and open an investigation into him?
That was an option that we had.
But did you personally advocate to the board that, or the other board members, that they should do that?
No, that was a discussion.
How was that discussion done?
Well,
If I showed you Exhibit R and showed you that it was in a text message, would that sound familiar?
no, but I mean, you could show, I'll look at it. I just don't recall it.
I mean, are you supposed to discuss township business in text messages with the other trustees?
On day-to-day operations, sometimes you have to have a special meeting or anything like that, yeah.
But all those are public records, right?
Yes.
Regardless, even if it's on your personal phone, they become public records because you're doing township business.
Right.
So the basis of this investigation was about only disclosing this email that purports to have attorney-client privilege material.
That was the basis, yeah.
There was no prior information or allegations that Chief Vinup had misused township resources.
No.
Now, in that email that she sent you, that's been marked as Exhibit T, Ms. Horvath advised you to appoint a private attorney because they know how to write charges and conduct a fair investigation, correct?
Correct.
Did you consider that?
Yes.
Why didn't you choose to do that?
Or
the board? Why didn't the board?
I'm gonna say that's all of us. That was we had a special meeting. Let's see, he was put on paid administrative leave on Wednesday. And the way we read the ORC was we had 15 days to complete the investigation, which we later found out that I guess we read that incorrectly, but so we had to have a special meeting. We did that on Saturday. I had three options. Mr. Kern was here. I believe Ed was you were not here at that meeting. And then, I don't believe Mr. Kern had any options.
Yeah.
Let me just interrupt because are you talking about something that you three spoke about in executive session?
No, this was a special meeting.
Okay.
Were any of the options that you considered an attorney?
Two of them.
Why did you choose, if this is an open session and you can talk about it, why didn't you choose an attorney to conduct this investigation?
Because the number one pick had a major case that she was handling. Matter of fact, I can't remember her name. She was the head of the GOP.
I can't answer for you.
You can't answer. Anyway, she used to be the head of the GOP over Warren County. So she had a major case. The second one I did not receive a response from. So when I came into the meeting Saturday, I was down to one option, and that was the only one we had.
So Ms. Horvath also said in that email, I do have some attorneys in mind if you need recommendations. Did you ever ask her for who those people were?
Yes, and one of them was actually the first
one who was considered?
Yeah.
Okay. So you considered two attorneys and then Mr. Williams, and was that it?
On my end.
On your end? Okay. All right. So in total, the board considered 5 people?
I had 3 days, so that's what I came up with. I have a full-time job too, so.
Yes. Why did you identify Mr. Williams as a potential candidate to be an investigator?
Because when Mr. Williams was on the levy committee, I didn't know I knew the fire personnel, but I didn't know the residents. So I called each one of them individually and did a short bio, just so that I would have more information, be more familiar with them and their experiences, their qualifications, and what they've done over their lives. And his was pretty extensive. So
Was it similar to what he read today?
Yeah.
Okay. Now, did you ever ask him, had he ever been the lead investigator on an investigation?
No, not the lead investigator, no.
Did you ever ask him if he was an investigator in an investigation?
I asked him if he'd ever done it, and he volunteered that he worked in investigations. I don't know if I have that with me or not, but
Given that this the misconduct at issue here involves a question requiring legal analysis regarding the attorney-client privilege. Don't you think it would have been prudent to try to find an attorney or someone with legal training to conduct this investigation?
I stated I did that.
You did, but you ultimately decided to go with Mr. White.
Option 3.
Did this decision at all, did the cost come into play?
That was discussed, yeah.
And this was discussed in open session, correct?
Yes.
How much would it have costed to have an attorney conduct this investigation?
How much would it have cost?
Yeah.
Anywhere from, the estimates were anywhere from $5,000 to $10,000.
And Mr. Williams offered to do it for free?
Yes.
So was that motivating factor in selecting Mr. Williams as well?
As I stated, the first option was not available, no response from the second option, so Mr. Williams was third option.
And you said you had what kind of a timeline to do this?
We thought we were under the impression we had 15 days to complete the investigation, and then if Chief Bennett requested an extension, then he had another 15 days.
So that's
why we did a special meeting that quick. We wanted it over with. I mean, it should have been, we thought would be over with.
Was that timeline that you were operating under, was that based on Ms. Horvath's advice?
I'm gonna object to that.
Was it done in open session?
I don't know. But but you can't ask me about what advice I gave him.
If it was done in open session, it's public record and it's waived privilege.
I'm sure it was an open session, but I don't recall that it was open session.
So you reached out to Mr. Williams, correct? About potentially being the investigator? Okay. And what did you tell him the investigation was about?
I just told him we had a allegation of misconduct with one of our employees, and we're looking into hiring an investigator.
That allegation of misconduct, who made the allegation of misconduct?
I guess the board did.
And were you involved in making that allegation of misconduct? You personally?
I am a board member, yes.
Just to be clear, this investigation had nothing to do with Chief Bennup's technical abilities as a fire chief or a firefighter. Correct?
Absolutely not.
Now you talked about the levy committee. You were on the levy committee as well with the citizens and members of the fire department.
Yes.
Right. Who created that levy committee?
Chief Bennett and I worked together on that, put that together.
And Mr. Williams was also on it?
Yes.
Do you know how he came to be on that committee?
Yeah, we were, I believe it might have been, I don't know if it was November, can't remember, maybe the first week of December, whatever, 2023. The trustees had gone into executive session, and when we came back out, when we adjourned the meeting, apparently Mr. Williams was at that meeting, and Chief Bennett and spoke with him, and he had expressed Mr. Williams' interest in being on that committee.
And so you observed both Mr. Williams and Chief Bennett on the committee?
Yes, correct.
Did they have a difference of opinions related to the levy?
Difference of opinions?
About how much the levy should be, or what it should go for, what the most important priorities were?
We all had a difference of opinions on what the priorities were, what we felt was a passable levy, and also provide for the needs of the department and the community.
Is it accurate to say that Chief Bennett was advocating for a more substantial levy than Mr. Williams?
Mr. Williams did, I don't think really had a number. That was just kind of settled out in the end. There was all kinds of numbers, and I don't remember exactly whose numbers were what.
Did you observe Mr. Williams and Chief Bennett have any disagreements during their time on the committee?
Disagreements? No.
They were
Discussions. I mean, yeah. But
any kind of, I mean, were these discussions serious in tone? Were they heated at all?
No.
Do you see how an outside observer might question Mr. Williams' independence to investigate this matter related to the levy? Related to his time on the levy committee?
oh, I'm sorry, say that again.
Do you see how someone observing the appointment of Mr. Williams to investigate this matter might not have been, he might not have been an independent investigator?
No.
No? Okay. You heard Mr. Williams say that, you know, you guys are friends, you two are friends socially, correct?
Well, yeah. I mean, like you said, we go to the same church. We didn't know that until what, Easter? And I bumped into it. I mean, that church is huge. So I have bumped into him, you know.
There was no requirement that the investigator be a resident of the township.
That was another thing that we were kind of unsure of as far as we thought it had to be a resident. If we did a private citizen investigator, it needed to be a resident. Maybe that's not true, but that's kind of how we were thinking.
And you don't have to tell me if you received legal advice from Ms. Horvath on this, but is that a question you would normally check with your lawyer on how to interpret a statute? Would you normally ask your attorney, if you had a question about how to interpret a statute, would you normally ask your attorney for their legal opinion on that?
Sometimes we do.
Not always?
Some of them are self-explanatory, but some of them we should probably ask more questions.
Did this one seem self-explanatory?
Yes.
Okay. This investigation was supposed to be about the disclosure of this email, correct? Okay. Were there any allegations prior to opening the investigation that Chief Bennett misused township issued devices or accounts?
Not that I recall.
Or that he deleted township records or data?
No.
And there were no allegations of potentially criminal misconduct?
No, no criminal misconduct.
And as you stated earlier, there was no need or requirement to read him his Garrity rights, correct?
Right.
Did you ever try to contact Chief Bennett directly during the investigation?
Yes.
Okay, why?
Because there was the investigation had stalled. I guess there was no response. So I believe I sent him a text.
And I can show you a copy of that. In the book, it's been marked Exhibit K Kilo 2. I can't recall. Does that have a date on it?
No, this is Saturday at 9:26.
Okay. Is that the text you sent to Chief Bennett during the investigation?
Township needs access to your Harlan Township email accounts. Could you send me your usernames and passwords for following? Then disregard sending passwords to any personal accounts that might be listed.
Okay.
Yes.
So it says the township needs the access to the emails. Was that for his position that he was on admin leave as fire chief, or was it for the investigation?
For the investigation. I mean, which he was on administrative leave.
And speaking of that, you recall the administrative leave letter, I think it's been marked exhibit CC.
I believe, yeah, it was dated 9/20, yes.
Now was Chief Vinup allowed to contact the trustees during that period of administrative leave?
No.
Okay. And he was only supposed to contact the township administrator, correct?
Yes.
So can you see how he might have been confused when you sent him this text message? When he knows he's not supposed to contact any of the trustees?
Well, it says, where is it? I'm looking to see where it says that. You are required to remain available, including coming to your designated workplace if ordered. To answer any inquiries during your normal working hours, you are not to come on the premises or contact the township or township trustees during their working hours absent prior approval.
So,
States he is not to contact. It doesn't say the trustees are not allowed to
but
contact.
then if he responds to your text message, isn't he violating that letter?
Not when he's on administrative paid leave. You're still a paid employee of the town.
I'm just saying, he's texting you, even if you initiated the text,
Yes,
he's contacting you.
he's responding. He's not contacting.
That's
He's
not the same thing, responding and
No.
contacting on the same?
No, if I send you a message, I'm contacting you. You answer, you're responding.
But can you see how he might be confused there? How he thinks he's not supposed to have any contact with you. And you send him a text message asking for things, when he also knows an investigation is going on. Do you think
That would be up to him to answer. I can't
Okay.
testify to his.
Did you know that Chief Vinup was represented by counsel at this time?
9/20.
That's
I don't recall.
9/20 is.
There was some point in there that we were notified that he got legal counsel.
Now, would you know that if he's represented by legal counsel as part of an investigation, you or the investigator shouldn't contact him directly?
No.
You wouldn't know that?
I mean, when you're on paid administrative leave, technically you're still employed of the township. He was on suspension.
But that contact was not related to his job duties as the fire chief, it was related to the investigation. You stated that, correct?
Yes, as his position as fire chief. That's what we were investigating.
I don't have anything further at this time, Mr. Shelton. Thank you for answering the question.
Thank you.
Does the board have any questions for trustee Shelton about anything that he asked? Kind of awkward, but you would need clarification on anything, ask now.
Yeah.
So you gonna ask him to call the next witness?
Do you have another
I
witness?
do. I'm gonna call Mr. Mason.
Okay.
And I promise this will be short.
Raise your right
Heard
hand.
You're gonna hold me to it, right?
Do you swear or affirm that the testimony you're about to give in this proceeding today is the truth, the whole truth, and nothing but the truth?
Yes.
Are you gonna hand him a bunch of documents?
Not too many.
Do you want him to move down next to you, so?
I can just walk up here. That's fine.
Okay.
Good evening, Mr. Mason. I can't say good morning yet. It's
Close. We're getting
we're
there.
getting there. We're getting there. But can you just state your name and say and spell your name for the record?
Steve Mason, STEVEMASON.
And Mr. Mason, what's your position with the township?
I'm currently the township administrator and assistant acting fire chief along with Chief Whitaker.
Now you were on both the email that Chief Vinup, that Ms. Horvath sent to the trustees with Chief Vinup on it, correct?
That sounds correct, yeah?
You were also on the email where Chief Vinup provided the information to the fire department. Correct.
Yeah, I don't recall, but if you have it, yes. I'm not sure which information
Well,
we're discussing.
if he sent it to the fire department, you would have been on.
Oh, yes, yes. Sorry, I didn't understand.
Right. Do you have an understanding of what the attorney-client privilege is?
Yeah, I mean, it seems kind of vague and who actually, it's not an individual representative, represented by the assistant prosecutor's office. It's the board as a whole. They don't represent any of us individually. If we have an individual issue that is outside the purview of their office.
Now, in your experience as township administrator, does the contact with Ms. Horvath, does it usually come directly to the board? Does it come, sometimes through you as administrator? Did it come through Chief Vinup individually as the fire chief?
I mean, majority of them have been as a group. And most of them recently, I've only been administrator. Maybe a year. I don't know when exactly that was, roughly a year. Yeah, I'd say most of them came as a group. Me is included in the group. Yeah.
Okay. Now, I know that email was marked, it said attorney-client privileged on it. Do you recall that Chief Vinup was not on the initial email thread?
I've seen it. I don't recall that. No, I don't remember.
But if you see it, would you say?
I did see it when you had it up here. Yes, absolutely.
Regardless of the marking, did you think that the information in that email was privileged?
No, I would not. And I had this conversation with Chief Vinup. It didn't. I'm not a lawyer, so I can't. But no, to me, it seemed like it would be options that I assume were maybe laid out in the ORC or laid out somewhere that they were, it's a rule that could be looked up by anybody. Again, that was my assumption. I don't know if I'm right or wrong, but that was my assumption.
Did you think that, so you think that would have been publicly available information?
That was my assumption. Yeah, that would be my thought. Yeah.
Now, were you interviewed by Mr. Williams in this investigation?
I was, yes.
Did he record it?
Not that I'm aware of, no.
Did he tell you he was recording?
No, not that I recall.
Did he take notes?
Yes, I believe so.
Okay. Have you seen the notes of your interview with him?
Yes, I have.
Have you reviewed them recently? Maybe as part of the public records request?
Within the last couple of weeks, okay. Probably.
I'm going to show it to you. It's Exhibit Z.
I have a copy here. You can.
Okay. You've reviewed this. Is this an accurate recollection of your interview with Mr. Williams?
It's somewhat out of context. I mean, I think there were some, and again, I just don't remember specific questions that were there. So I think there's some context missing in some of these questions or answers. I mean, you have answers without questions shown on the document. So it's, it's kind of hard to get a context on something when you have an answer without a question.
Okay.
Attached to it.
Well, it sounds like, related to the third question, anything else I should be aware of? Based on that, it sounds like he asked you an open-ended question. Is that accurate?
I don't recall that being the question. It's written down here, so it was. I think it was more of a conversation from that point forward. I mean, just the context taken here doesn't make any sense that it would not have some conversation given the way this is written.
So from your recollection, there was some questions going back and forth between you and...
I believe so, yes.
Okay. But those aren't reflected in this document.
Correct.
Nice. Stop you. Were you sworn?
We just did.
Okay, I'm sorry.
Yeah.
I missed that.
He turns.
Yeah.
Turn face to turn.
Okay. Just want to make sure.
Now looking at number 2 in there, and then also looking at the email, I think it was marked Exhibit 2 or 3. It was the email that was sent to the fire department where Chief Vinup lays out those options. Was anyone on that email that was, as far as you know, not part of the fire department?
No, there were a couple of names that Mr. Williams asked me about. We have some new members coming in. I no longer do all the interviews. We hired somebody to do that, so I don't. There's probably 5 people that I couldn't pick out of a lineup currently that are on the roster.
So as far as you know,
Yes.
that wasn't shared generally with the township or the public. It was just shared with the fire department.
Yes.
And obviously, I'm not gonna ask you to, what was in Chief Benham's head. But why do you think he sent that email to the fire department?
With a small department, there's a lot of involvement from the members that maybe you wouldn't have at a larger department. So there's more ownership by the members, and I think it was sent as an update to them. This is the situation we're in. We had tried for a couple of years to get a levy passed. It had been pretty disheartening not to get a levy passed and concerning for the members. And I believe it was sent as this is kind of what this is the lay of the land. This is what happened, and this is what might happen.
Nowhere in that email does he say anything about the trustees taking the wrong approach or advocating for something against the fire department in that email, does he?
Not that I'm aware of.
I don't have any further questions for Mr. Mason.
Pretty sure.
Told you.
Does the board have any questions for Mr. Mason?
You guys have any questions? I have one.
Ask him to call his next witness then.
And you have another witness?
Yeah, can we take 5? And we have one last witness, so it'll be Chief Benham.
Okay. You guys are all right. We're gonna take a 5-minute recess.
Oh,
All right, we're gonna resume the hearing. Does council have any other witnesses to bring forth?
Yes, sir. Our last witness is Chief Dusty Bennett.
You'll have to stand up. Do you swear or affirm that the testimony you're about to give in this proceeding today is the truth, the whole truth, and nothing but the truth?
Yes. All right, Chief Dusty, I will probably use that interchangeably, so forgive the informality. I think we've come as close to convincing everybody to not ever become a lawyer as we can tonight, leading up to this point. But we've heard a lot of the background, so let's focus on the conduct at issue in the language of Mr. Williams' investigative report, okay? But before we do that, let's just get a little bit of background about yourself, okay? So how long have you been a fireman?
For 24 years,
And how long in Harlan Township have you been a member of the fire department?
29,
And when did you become chief?
May of 2019.
Okay. And during your term as a fireman in Harlan Township, have you ever faced disciplinary action?
No.
Have you ever faced disciplinary action outside of this matter as chief? Okay. So let's focus our attention first to the three instances that Mr. Williams describes in his report. And why don't you go ahead and put the report up in front of you in that binder. It is Exhibit D. And this is Mr. Williams' report. So we talked, and my colleague Matt talked with Mr. Williams about, and this is on the page right after key findings, unauthorized disclosure of privileged information. So we have 3 alleged instances of unauthorized disclosure of information. Okay, I'm right here. The first instance being September 4th, 2024. And we'll talk about that in a moment. Mr. Williams has already acknowledged on the record here tonight that given the having additional context of Trustee Curran's letter, that the second instance was not unauthorized. So I want to focus our immediate attention on number 3. And it says on October 15th, 2024, Chief Vinna forwarded the privileged email to his personal AOL account. When did you and I first talk about potential representation in this investigation?
October 15th.
Okay.
October 15th, sorry.
Okay. And did you indeed hire us on October 15th?
I did.
Okay. And as part of that initial onboarding, if you will, did we ask you for certain information relevant to the investigation?
That is correct. We did.
And in asking for that information and providing us with that information, did you provide us with an email from your AOL account that is the subject of this investigation?
That is correct.
Okay, thank you. Let's turn our attention now to the September 4th email. We've heard testimony from all the other witnesses, okay? But why don't you go ahead and do me a favor? It is Exhibit A in your binder. So if you flip back to the last page, you see where the subject of the email is minutes, correct? Last page of Exhibit A.
Yep. Sorry.
That's okay. And are you a recipient of that email?
No.
Is there any designation of attorney-client privilege or confidentiality on that email in the subject line?
No.
Okay, so let's flip back a page or forward a page, if you will. And that email actually extends up another page. And the email that I'm now looking at is Friday, August 30th from Catherine. And are you a recipient of that email?
No.
But what's the subject of that email?
Reply for minutes, attorney-client privilege communication.
Okay. And so flipping to the first page of that attachment, you are indeed attached now copied on this email, correct?
That is correct.
Okay. So when my colleague Matt was asking Trustee Shelton questions, he referenced an Exhibit T, and I want you to go to Exhibit T now. This is an email that Catherine sent to Marcus regarding a potential investigation into you, correct?
Yes.
I'd like you to turn to the third page of that email.
Okay.
And if you could, read aloud the last full paragraph. That starts with, please share.
Please share this advice with the rest of your board. Just a reminder about the attorney-client privilege. The privilege belongs to the board and not to any one trustee or township employee. I can't waive the privilege and am bound by confidentiality as is every other attorney in my office. In parentheses, I did share the email I sent with you with your levy options with David Fornshell and then First Assistant Prosecutor Adam Nice, but they are also bound by confidentiality. All township employees and members of the board are also bound by confidentiality unless and until the board, by a majority vote of its members, decide to waive the privilege and share the communication.
Okay. And so in that email, who does Katie indicate the privilege belongs to?
I mean, you just read it.
Yeah, okay. Does Katie say that the privilege belongs to the board?
Yeah, and also,
Okay.
yeah,
Yes.
also the township.
Now, referencing back to Exhibit A, and I don't need you to flip back. Are you a member of the Board of Trustees?
No.
So when Katie copied you on that email, is it possible, in your opinion, that that was improper?
Yes, now looking at it,
That's why.
if I wasn't a member of the board of trustees and she wanted to keep it client privilege, then I shouldn't have had it.
Okay. Now, she also talks about how confidentiality extends to other employees of the township, correct?
Correct.
And your email that you sent, who did you send that email to?
To the department members.
Only?
Yes.
And all those department members are employees of the city?
Correct.
So they too would be bound by confidentiality.
They would be.
Okay, thank you. Okay. I want to now talk about deletion of the potentially relevant data. Okay. And I'm now referring back to Frank Williams' report.
That was D.
Yes. So let's start with the first allegation. Mr. Williams says that he reviewed your township laptop and all emails and web browsing history have been deleted. Is it true that all emails have been deleted?
No,
What had been deleted?
there was no emails deleted.
Okay. So what about the web browsing history?
I did clear the web browsing history
Why?
for personal reasons. Because I used that computer for personal. So
Did you have saved passwords?
I did.
Did you have access to your bank account saved in the web browser?
I did username and passwords. It was just one click.
And other passwords to other personal information that presumably you didn't feel that Mr. Williams needed to have access to?
Correct. There was the EMS reporting, which is, and fire reporting, FEMA, and also website. So yeah, as well as my personal.
Going back to your emails for a moment.
Okay.
There was a lot of discussion with Mr. Williams how he looked in the trash and could only see 5 days worth of deleted emails. Can you explain why that is?
Because I check my spam folder quite frequently. Because with TDS, a lot gets sent to that, especially with like the Ohio Township News or International Association of Fire Chiefs, or sometimes they just get sent to there along with other personal emails. We also have difficulty sending emails from TDS at times, especially with government agencies. As Steve has trouble with the DEA, as I did when I was EMS captain. So I check the spam, and when I check it, I delete that trash and junk. So
If Mr. Williams looked in the various other folders of your email account, would he find numerous emails in those folders?
yes, sir.
Sent mail,
Yes,
other folders within your inbox of mail that you had received?
correct.
Okay. So is it fair to say, and again, I'm going to ask you again because I think it's important, that all emails had been deleted? That is an inaccurate statement.
That is correct.
Okay, thank you. I want to now talk about your cell phone. So there was a lot of talk about the cell phone and some language that you purportedly used about something you did to the phone.
Correct.
Can you explain to everyone here the issue with your cell phone?
So the cell phone that Frank is claiming was a cell phone that broke. The cellular service and Wi-Fi quit working on it. I don't know how long, over a year, maybe year and a half ago. I worked with Verizon trying to get it to work. They couldn't figure it out. They thought it was a SIM card. I got a new phone and used that phone throughout. So those messages that he is claiming to be deleted and whatever else it was on there, because I know I had my contacts on there and there's probably apps still left, but a lot of the personal information was all deleted off that way before any of this started.
Okay.
Yeah.
And it doesn't say anywhere in Mr. Williams' report when you deleted information off of your phone, correct?
No.
Okay. And it doesn't suggest that Mr. Williams did any sort of forensic evaluation or utilize any sort of forensic service to identify when you deleted information off of your phone?
No.
So it's possible, and based upon your explanation, reality, that this information was deleted prior to, in many instances, this investigation. That was a poorly worded question. So there was deletions of information off of your phone that predate this investigation.
Correct. Yes.
Okay.
Yeah.
And so there's nothing nefarious that you were doing. There was nothing you were trying to hide by deleting your phone.
No.
There was nothing there was no conduct that you were engaging in either with your email account or with your cell phone to obstruct Mr. Williams' investigation, to destroy evidence of wrongdoing.
No.
Do you think you've done anything wrong?
No.
So on that topic of obstruction of the investigation, you failed to respond, as indicated in Mr. Williams' report, multiple requests for information in a timely manner. We heard in the testimony from Mr. Shelton that he had texted you and didn't get a response. Can you explain why?
When Mr. Shelton texted me?
Mm-hmm.
Yes, because originally, when I was put on admin leave, I received a text that evening from Trustee Kevin Kern, and he stated I was put on paid admin leave for potential misconduct, pending investigation, and not to have contact with trustees or fire department members. And then I tried calling him right away, and he texted me right back and said, I am not allowed to talk to you. And then the next text, I believe, was, are you able to drop the Tahoe off? And I told him, I believe it was Friday. I told him I could do it. I think it was. But yes.
And you did drop the top?
Yeah.
Okay.
Yeah, that morning.
So fair to say you were following the instructions you were given by a fellow trustee?
Correct.
Okay. And so when Mr. Shelton reached out to you Is the reason you may not have responded because you were complying with the directive you received from a fellow trustee?
That's correct.
Okay.
That's why I contacted you.
Yeah. All right. Moving on to the second allegation of the obstruction of the investigation. On October 15th, 2024, Chief Vinup was directed to meet with the investigator on October 17th, but failed to do so. There's a lot of discussion about this, and I'm not going to revisit all of that, but just you engaged my firm on October 15th, correct?
Correct.
And we reached out to Investigator Williams that same day, correct?
Correct.
And is it also true that we told Mr. Williams that we needed to speak with him before agreeing that you would sit down for an interview, correct?
That is correct.
Okay. On October 17th, did you receive any phone calls from Investigator Williams?
No, I did not.
Any emails sent to you asking where you were and why you weren't showing up for the interview?
No.
Okay.
There was just no time frame given. There was Steve sent an email. It stated meet at this time or after 4 o'clock. I believe it's 9:30 or after. Nothing else was from that. All communication was between you and Brian.
But in that communication, directing you to participate in an interview on the 17th, that was prior to my firm having reached out to the Investigator Williams, correct?
His email?
The email, yes, I'm sorry. The email that you received to participate in the October 17th interview. That was before I had reached out to Mr. Williams, informing him of our representation. If you don't recall.
I don't recall. It was right around that same time. I can't remember if we had a conversation on that the first time or when we talked later, but I know you reached out that same day. So
is it fair to say you were following our instruction?
Yes.
And is it fair to say that we had reached out to Mr. Williams to better understand the scope of the investigation?
Correct.
And at no point in time did we indicate to anyone on your behalf that you wouldn't sit down for an interview?
That's correct.
Okay. So there was also a lot of discussion, and I'm now moving on to number 3 in Mr. Williams' report of obstruction of the investigation. Chief Vinup's attorney stated that Chief Vinup would provide the password for only one of his township accounts, claiming he didn't remember the passwords for the other 2. Can you explain that for everyone, please?
So the one TDS was the one that I used.
And that's the email account that Mr. Williams got access to.
Correct.
And that's the email account that he claims all the emails were deleted.
Correct.
Got it. Okay.
There was another one that is provided by the IT that I do not know the password.
Why not?
It was given to me and I just hadn't used it and forgot.
So it's not an email account that you use regularly?
No.
Okay.
No. So that was provided by the IT, which, and then the other one, there was the Captain Vinup. I believe that's the one he's talking about. But obviously I haven't used that for 5 years.
Why not?
Captain versus Chief.
Right. You're no longer the captain.
Correct.
Right. So it's fair to say that you provided Investigator Williams all the information that you had.
That's correct. Even the Captain Vinup emails from when I was EMS are in his files still. Because I transferred from Captain to Chief, and all those files transferred over to my Chief for reference. So he had access to the Captain Vinup.
Do you believe that there would be any relevant emails in the Captain Vinup email account pertaining to his investigation?
No.
Mr. Williams also talks about the absence of messages with fire department leadership, who he likely would have discussed the key issue vital to their department and how that raises suspicion in his opinion. Did you regularly communicate with the members of the fire department?
Through business meetings and officer meetings is how we typically basically on the levy, it was between Steve and I, if anything. But as far as going to the next office.
Right. So a lot easier to just walk across the hall or walk next door than sitting down and typing out an email. Fair?
Right.
So simply because there's not a lot of email communications with fire department leadership doesn't mean that there's not a lot of communications going on.
That's correct.
And also doesn't mean that you deleted communications either, correct?
Correct.
Okay. There's an analysis done by Mr. Williams where he says there was a disregard for confidentiality. We talked about this previously. When you sent your email to the members of the fire department, do you believe that you disregarded confidentiality?
No, I don't.
Do you believe that you were breaching or waiving attorney-client privilege?
No.
Had you been instructed that that communication was to remain between Ms. Horvath, yourself, and the other recipients on that email, would you have disclosed that to the other members of the fire department?
If I believed it was.
If
no,
you were
but-
instructed not to.
No, I would not.
But you weren't, correct? And as we saw in Ms. Horvath's email, you're not a member of the board. So you don't have the attorney-client privilege, as she wrote. And as she said earlier today, the documents speak for themselves, right? And in that same email, confidentiality applies to all employees of the township. And remind me, who did you send that email to?
The members of the fire department.
Okay. This has been a long investigation, and I know Mr. Shelton has described how he wished this could have all been over sooner. He thought it would have been over sooner. And can you describe the impact that this investigation has had on you, personally, reputationally, emotionally?
I don't know if that question's relevant, but if you want to let him answer, it's fine. It's not a big deal.
You can answer. I don't have a problem.
Well, let me ask you first. Do you think this investigation is a big deal?
Absolutely, I do.
Okay. And then you can go ahead and answer my first question.
I'm very proud of my name. I've been in this community all my life. I've stayed here because of this fire department. So to see what's been posted on Facebook, to see the questions I've been asked, and the assumptions out there, to see this report, it's taking a toll on myself, taking a toll on my family. I mean, drive by the firehouse, my kids start crying. Because daddy's not at the firehouse anymore, and that's where they love to go and hang out. So lost a lot of sleep. It's they're my family, this department, and not being able to talk to my family for 2 months now, it's taking a toll.
You still want to be the chief of this fire department?
I do.
Why?
Because I have unfinished business here. I want to watch this department grow. If I could keep it volunteer, and I would. But we're past that point. I'm very passionate. Sometimes that's displayed where it's misunderstood. But this is, sentimental ties. My father being here 20 years as a lieutenant. Fish fry named after him. Two of my kids have gone through that program. Got 2 more to go through the cadet program. You know, I owe it as a senior fireman and chief to the younger members coming in to be raised the way I was. And that's through Chief Minton, that's through my father, the officers of the department, and founding members that I was on.
Any other questions?
Does the board have any questions for Chief Benton?
I'd like to see the email that was actually sent, a hard copy, went to the community here, to the fire.
It's 3 or 4.
The other one as well.
Got a couple of questions for you, Chief. Just very simply, did you share a confidential privileged email from legal counsel with recipients that were not on the email thread?
No.
You did not?
Did not share it with.
You did not share the information from that email?
The information?
Yeah.
I talked to one member on the phone, or one levy committee member on the phone in reference to that email, but I did not.
When did you stop using, there's some confusion on the phone.
Mm-hmm.
There's like 3 phones. When did you stop using the phone that's on the township plan?
That was stopped using the one September 22nd, 22nd, yeah. I switched over to the personal plan because I purchased the one phone that hadn't been activated to separate, and I never did activate it or assign a new number, and I didn't switch my phone over yet.
You switched it to a personal phone?
Correct. The personal plan.
And personal plan. Switched it to a personal phone or a personal plan?
It was both.
Both? Yep. Okay. On September 22nd?
Yes. I believe that's what it was.
I have. You guys have any questions for Chief?
Why did you forward that?
Why did I forward it?
Yes, sir.
Because I felt it was very important for the membership to know, have the information, to be transparent with the membership. I'm always trying to be transparent, trying to inform them. They're not always at the firehouse. They're not always able to attend all the meetings. So I do try to communicate with them, and I felt that was an options that they had, that you had, and that would be brought up. I was just keeping them updated.
It would have been easier to come forward in the very beginning and put this behind you. Day one.
What do you?
Immediately. And talk to the board and get this resolved where we would explain yourself, and there wouldn't have been, we wouldn't be where we are today.
Was I given that option?
You can contact me anytime, right?
Huh?
You can contact the trustees anytime at that
Not when I get a text message. When I was put on September 18th, I was put on admin leave, got a text message that evening, not contact the trustees. How was I able to contact you and resolve this and come forward?
Well, there was 2 meetings, 4th and the 18th, whatever the dates were in September, that we wanted to speak with you. And you weren't at the first meeting, and then I asked you to be at the next one. You said, I can't be there, I got work.
Speak to me in reference to what?
In reference to this email ordeal.
That is incorrect. September 4th, the email was sent. That was the first meeting. You did not. When did you ask me to speak? I did
We
not
wanted
send.
to talk to you that evening, and then at the next meeting in September, I sent you a text.
September 18th.
And then I asked you, I said, well, if you can't make it, will you be available for a phone call so we can talk to you on a conference call?
That is correct. That's the same trustees meeting. September 4th, you found it on August 30th. And I believe that was the Friday or the 31st, one or the other. September 4th is when you got the information. Or September 3rd, I believe. And I received the email. Was it 3rd or 4th? And I sent that to the membership. Why did you need to talk to me that September 4th meeting?
We wanted to discuss the issue with you. And then it proceeded to this. But anyway, that's where I'm at with it.
There's no communication.
Anybody have any other questions for the chief? Does anybody have any follow-up questions for the investigator?
I have none.
Well, that concludes the testimony and evidence in the hearing.
Mr. Shelton,
Something.
to finish our case, we don't have any more testimony, but we want to move all of our exhibits that are in that binder into consideration for the record. All of those documents were either discussed and showed to witnesses during this hearing tonight, or they were provided in response to the subpoenas and the public records request from the township. So they're all relevant to this matter.
Right.
So we ask that you include that binder and all the documents in the record.
You all okay with that? Are they all labeled?
Yeah, they're all, it's exhibit A through EE.
A through EE? Okay. So,
There is duplication with some of your numbered exhibits.
yeah, so, that's okay, we'll just let that be, and then, you should, decide whether you're gonna accept them. Admit the exhibits.
We gotta take a vote.
No, just admit them.
Okay, let's admit them, the exhibits.
Yeah. And these as well, these were your investigator that did
All right.
this.
And then we'll also admit the investigators'
Yeah.
materials.
And there's no one else that you all wanna recall, you kinda skipped that part too, so he's presented his case, is there anybody you wanna recall to clarify any issue?
They didn't have any questions for the investigator, so.
Okay. Well, I'm asking if you have questions for the investigator based on his questions.
And additionally, as part of my case, I'd like to note several objections
Okay.
to the proceeding on the record.
Sure.
Several were made during the course of the hearing, but so I renew all those objections that were previously made. I'm gonna make a few more here. Related to the scope of the investigation, the investigator went beyond beyond the allegations of misconduct. The chief been improperly disclosed confidential or attorney-client privilege material to search for additional actions to support a misconduct finding. We find our position is this violates Chief Bennett due process by failing to give him proper notice of the basis for the investigation. Additionally, the investigator was either biased or at a minimum appeared biased and not qualified to conduct this investigation. Mr. Williams previously served on the levy committee and took positions that were contrary to or had different positions than Chief Binup. At a minimum, there's an appearance that he was not an independent investigator. He also stated that he's personal friends with the president of the board of trustees. There's other people that could have been appointed as an investigator that don't have this appearance of bias. Additionally, he was not qualified to conduct this investigation. In her email, Ms. Horvath recommended that an attorney conduct the investigation. Mr. Williams does not have prior legal, law enforcement, digital forensic examination experience, and as he stated, this was the first investigation that he conducted as an investigator. There's an important legal issue here related to the attorney-client privilege and legal conclusions in the report, interpreting statutes, interpreting the meaning of the words misconduct, malfeasance, that somebody with legal training should have been conducting this investigation. Additionally, we renew our objection to the failure to produce the relevant documents in a timely fashion in order for us to adequately prepare for the hearing. As we stated before, we didn't receive these records until 2 days ago, so that was November the 18th. So just for the record, Ms. Horvath stated that Chief Binup needed to provide any requests for subpoenas by the end of the week after the last meeting. So that end of the week would have been, I believe it was November the 8th. Those were sent in a letter, which is Exhibit F on November 8th. That letter states that to provide the records by November 13th and to transmit them as they become available rather than waiting for all records to become available. We received an email from Assistant Prosecutor Nice on November 13th saying that he had to review them. We did not receive that production until November 18th, 2 days before the hearing, again containing 34 gigabytes of documents which we couldn't digest in just 2 days. Additionally, we asked for Chief Binup's entire personnel file from his time as chief. It was only provided beginning in 2024. I previously stated our objection to Ms. Horvath not appearing as a witness in this case, so I renew that objection. Additionally, we object to Ms. Horvath continuing to advise and represent the trustees. Her continued involvement in this matter violates Rule 3.7 of the Ohio Rules of Professional Conduct, which forbids any lawyer to act as an advocate at a trial in which the lawyer is likely to be a necessary witness. She was personally involved in all stages of this dispute, including the chain of events that led to the error in the language of a proposed fire department levy, discussions among the township trustees and between the trustees and Chief Binup's department about how to fix that error. On October 24th, Chief Binup, through counsel, requested that she recuse herself from advising the trustees on the conduct of the investigation and any actions that they may take as a result of it. She refused, or her office refused, to have her recused from this, and she continues to advise the trustees while not making herself available as a witness. Lastly, our position is that Mr. Shelton, that you are conflicted from voting on an action related to Chief Binup. Mr. Shelton's allegations are the basis for the charges here, and he's also presiding over the hearing, and so he should recuse himself from any vote on the action against Chief Binup. I cite the Kiger versus Albon case, 76 Ohio App 3rd 301, as a similar situation where an Ohio Court of Appeals found that the fire chief was denied his due process, where his accuser oversaw or sat on the board of trustees that decided to terminate him. The bias is clear here against Chief Binup. There's statements that are in evidence from Mr. Shelton that blame him for the ballot language, despite another email that Chief Binup sent the right language, and that it was Ms. Horvath and others' oversight that is the reason for the improper ballot language. So we are requesting that Mr. Shelton recuse himself from participating in the vote on whether to accept the investigator's charges and taking any action. Those are my objections.
So you all should note his objections for the record. And then you should proceed to deliberate. There's a very recent case that requires you to deliberate in public. So as my
Should I close the hearing?
yeah, sorry. Well,
Before I do that, can I ask to make, just, I'm not gonna sit up here and we've been here long enough, I'm not gonna make some long closing argument, but there are some words I'd like to say on Chief Bennett's behalf, in addition to the objection. Okay. We've all been here, we've all seen the investigator's report, and it's no knock on Mr. Williams. I think he tried and he did the best that he could, but there are no legal or factual grounds to find that Chief Bennett committed misconduct or malfeasance as the investigative report recommends. In order to find that evidence, it has to be supported by reliable, probative evidence. We don't even have a legal answer as to whether this email was even attorney-client privilege. So to find that he committed misconduct by disclosing an attorney-client privilege communication, it's not supported by reliable, probative evidence. Okay, and there's certainly no grounds to terminate Chief Bennett. And look, we've all been here, we've heard the evidence. If the board votes to terminate Chief Bennett, he will appeal that. He's fighting for his job. He wants his job. And if he appeals, everything that happened here in this investigation, in this hearing, goes up to a common pleas court judge who's going to look and scrutinize everything that was decided in this case. The objections that we've raised, which there are many, and several that are supported by the law. On appeal, additionally, we're going to argue that this case was frivolous. And if a court finds that a case was frivolous, we have the ability to request that court order that Chief Bennett's attorney's fees are paid by the party that brought the frivolous action. That's up to the court. If they decide to grant that, that then comes back on the township. So what we're asking you to do the right thing here tonight. Find that Chief Bennett did not commit misconduct. Vote not to terminate him. He's contesting this because he cares about his department, his firefighters, and this community. He's been on this department for almost 30 years. He's been the chief for 5. And he's lived in this community his whole life. He wouldn't be fighting for this if he didn't care. He's willing to put this behind him, work with all of you, work with everyone in this township to make it better because of how much he cares about this community. So again, I ask you to do the right thing. And let's start over tomorrow with Chief Bennett, remove him from administrative leave and reinstate him to his position. Thank you.
you don't need to do any motion. You just need to explain that you're going to close the hearing.
Something went wrong.
And
Please try again.
and then you'll proceed to deliberate. Whoever's going to deliberate. Proceed to deliberate.
So that concludes the testimony and evidence in this hearing. The board will take the exhibits that have been marked and make them part of the record. And you and I were on the same page. During the hearing, Chief Bennett's counsel alluded that Trustee Shelton could be biased in this hearing. Therefore, I'm going to recuse myself from the deliberations. of possible disciplinary actions to be taken by this board and the vote. So it's going to fall on you two to deliberate, and whatever the disciplinary action is, and smile. But we have to do it here.
So for you two, I would recommend going through the charges and making your findings. You could either take turns doing that. But I think you should find that the charges were either substantiated or unsubstantiated. Do that out loud on the record, give your reasoning why, what you're basing that on. And then, we'll follow that up with something in writing if needed, but we'll proceed to your vote after you deliberate and vote. And just so that you know, if you need time to review any of the exhibits, any of the things that you heard, you can take the time to do that. And you can do that. You can deliberate. You can deliberate on a later date if you want to, but you're still gonna have to do it in open session. But if you need time to review exhibits, you can take that time. It's up to you whether you want to move forward tonight or not. Just trying to give you that option.
How would that fall with the 15-day deal?
Well, it needs to be within, I mean, if I would recommend scheduling a special meeting for like tomorrow or the next day, if you need time to review the exhibits.
Maybe 24 hours. Right?
24, yeah.
So it can't be tomorrow. Because
Well,
it's already tomorrow.
oh, you're right. Right, so I guess Friday.
There's a lot. No, I think there's a lot.
It's Wednesday.
Thursday. Well, it's morning.
I think I would like to go over a lot more information. There's a lot to digest.
You'd like a chance to review the exhibits?
And we could have a meeting on Friday.
Okay, so why don't you go ahead and announce when you're gonna do that, what time and where? In here.
Room available.
Should be.
You available Friday?
Are you available on Friday?
I'm available on Friday.
They don't have anything marked in here for Friday.
That's fine, whatever works for you. Anytime Friday.
Just need to say
What time? Were you available?
Do you need me? After 3.
4 o'clock Friday.
Yeah.
People work. Yeah, no one can be there.
Okay,
That's good.
what's the consensus?
Oh, we'll all be here.
Making the decision tonight is not that. Yeah.
Let's get it over with.
Exactly. No,
Let's do it.
it's
Fair that you get time, but his attorneys didn't.
You should. It makes me need to.
I mean, you heard everything, just like we did.
It's up to you. If you feel like you want to review records, you can. I mean, you're the body that has to make the decision. on the whole thing. So, you know, I would recommend that you're careful with your decision. So whatever you want to do. If you want to take the time tonight and stay late and review the documents here, you can do that. I think we only have one copy of the binder, so unless you have other copies of your exhibits.
We have another copy. We do.
You do?
Yeah.
You have a set that one of the, that, so they each have one? Oh, Kevin. Those will be duplicate to what's in that binder, I believe.
Oh, she said something.
But that's okay, you can take them in. Make sure his kids get mine. Yeah, I mean, it's an open session while they deliberate, but if they, read documents, if you watch them, that's fine.
I am leaving the audio on this time, just so you're all aware.
But it is?
The audio is on, yes, since they're doing open deliberations, the audio is on.
We can also. Right? My friend will appreciate it.
Gonna be up to 5 I know.
Did I say that? What did you?
You're right. They get out quick.
Yes. It'll go right through me.
This point.
You want it to.
Instead of change. This is special.
I just want to make sure.
I don't know.
So where's your, I probably will make sure. I just want to make sure.
Got it. Long time in here.
Yeah, it's up past, it's on the left. On the left. Go down all the way.
Did it have ice in it?
I mean, that wasn't in here, so I just want to make sure that I can't question me. I'm confused to say anything. Just. How are you, Matt? But now I know.
That's been doing all right.
You are short for it?
12 years.
Actually. Who said that? So. Exactly. And that's what I told. Yeah, well, that's why I.
Only at 15 and then.
Come on.
Anyway, but I just wanted to make sure.
True, very true. Nice to meet your time. So I will, whenever you start to discuss, be online, and you should have everyone be quiet so that the.
Oh.
It catches my hearing. Sorry, I didn't mean to interrupt.
And I got pictures of me in the same light.
I still live here.
Yeah, there's still people online.
Are you getting us to have tomorrow? Are you getting us tomorrow? I know. Oh, shit.
Just give it 5. Yeah. Just sometimes meetings just gotta direct like 6:30.
I could at this night in my
Yeah.
Or grandma's doing it. Rough time.
It's about 2 hours.
Yeah, really.
I should have called Charlie and time. Charlie understands.
Yeah.
It's freaking yesterday.
So I'm just gonna.
I was just, can't you not host all the This will be recorded. Delivery of
Yeah, that's Katie, no question.
I stopped.
The live stopped. You mean? More than.
The live.
Oh, it stopped.
Yeah, the live stopped.
Wasn't here. I have a coach.
Sorry.
So, what I would say is, I hope
This week.
I was pulling my hair. Interpret it, I mean, interpret it how I see it. To deal with that. Smart individuals, you can, you know, you can look at this and say, you know, what you think they're really.
People are going ballistic.
Yeah, so.
Yeah, I was.
Yeah, so I think I'm out of time, but then we start a new meeting. So once the. I know, so if you don't put on, I'm at the start of the meeting, I think YouTube has shut us off on time.
Okay.
So I think we're limited on how many megabytes, so I'm gonna try to start a new meeting. And see if that works. It's, yeah, it's. It's still streaming.
Many kids were there tonight.
His defense was saying that it.
Carter, Charlie.
It is focused.
Yeah, grandmas get text messages.
Not recommend that?
I recommend that, and also
Everybody's sleeping.
all of that stuff.
Yeah, I mean,
so
good
I
and
would-
bad.
I think I'm not doing this one now. Well, I'm gonna restart the meeting.
Let's try.
So it has been.
That's what I was looking at.
Next week is not.
Well, I would have been able to be there next week. Week, but then it'll be a meeting.
What'd you find? Are you driving back to school?
Yes, so I lost my cable. Is there something like pinch back there? Because I think that's possibly the issue.
Worthington's in Columbus. I mean, you emailed me.
It's lost the signal to the server.
This wire and the black tape
Yeah.
that we're standing on?
I don't know if it's the cable or if it's, says I've lost connection
That's
to the
what,
server.
you know, that you
I
can tell
am
us
not
probably. It's the blood juices. Which is. People from Cincinnati could drive out, but people from Cincinnati, yeah. No way that there's a thousand.
Still on. You're still slacking.
Yeah. Everybody's going to
But it's not. I don't, I'm not a tech guy, I don't know how to. Hey.
Oh, LM Gigs
going, internet went down.
LM Gigs.
LM Gigs doing service.
Service work.
Oh, it's been, I forgot about that.
There's your answer.
Yeah.
I can't. Now, it's being recorded locally on my computer, so I have, all of it's still being recorded on here. So it can't be posted, but so put that out there, it's not, leave my name out, it's not
We did.
Yeah, we're still recording locally, it's just LM Gig got the internet down, we make maintenance amendment, so that's why I have
Hold on, sign.
Bad.
We're gonna turn.
We have to check. Come on. This is the only time we get a chance to question.
I'm not.
Yeah.
They ran it down your brain. LM Gig is doing a service.
I was the tube screw out of the wires.
That's even worse.
So that's easy walking around, but it's not right, not in real time. Well, it never, it's just delayed. It's back on. It's back on.
Is it?
Yeah. It's going, Steve.
It's not going. See, it's a good answer. Like
Good
that.
job, Steve. Yeah.
All right, so we're going, the white still says.
Oh, yeah, 3 times.
In Warren County, and then I have.
It sits a little behind.
Yeah, I don't know, it still shows an error on my screen, but you say it's working, it's working.
I see everybody walking around.
Yeah, well, it started to buffer again. In and out.
Okay, exactly.
Yeah, so it's starting to send me
Casey just called, texted me, said, stop me.
Yeah.
One time I see down.
I think it's gonna be dependent upon what they're doing.
Like my
What else
hours
we
right
can
now
do.
are so good, and I have little kids.
What stopped again, because LM Gates got stuff up and down. On the lines, they're doing
Nobody's trained to 2:30 in the morning.
Yep.
So Tom is gonna keep it running.
I've never had. I've had mediations, but not.
Yeah.
I've had criminal trials where you just
For the jury.
finish and the jury's out.
Yeah. Yeah.
I ain't got nothing to do.
Great. Kind of like this.
Yeah, it's gonna be cold.
Your office is in London.
You want Italian ice?
All right. A couple times.
Up for a second, back down. So Ellen Giggs doing maintenance.
maintenance.
What are the chances?
Casey's
Been off and on because I think they're taking the system up and down, doing other things. Yeah, so it's being recorded so I can post it later.
Yeah, some criminal mistakes. He does, but he does more than he does.
Do you have that?
Yeah, you think. And they just got pretty good.
Because that's like what the state of it.
They should.
He just said they're gonna be busy tomorrow. Because I always want to do that too. We're in God's country. Yeah. There's no coffee.
No coffee.
You gotta go to your kitchen.
That's not promising for me.
Which way are you going? And I'll tell you.
Most of them going wherever the coffee is. You're out.
Starbucks is UDF still open. UDF probably in Blanchester.
Go get a Mountain Dew.
Yeah.
Stop on the way out on the lawyers.
Yeah.
Right here.
This work is fine.
Yeah, you'll pass her house and go that way.
Okay.
Actually, I have my husband bring a cup of coffee.
How long were you?
5 years. So that could be. That's not her birthday. 70s. No, that was the.
What is, I thought of it like a tin-till.
Yeah.
She came over and I'm like, you're not a senior, you're not going to.
She's not, is she? No.
She's not.
She's 11.
Yeah.
No, she's in a stroller.
Yes. Yes, before she could talk with that smart mouth.
We're sitting at that little table with the umbrella.
Oh, forgot about that.
I have a visit to TKU on Monday. I wanted to do pre-nursing and then go into labor and delivery.
I had my keys with me. I went out there.
That's more than Mandela effect. Because this is.
You guys robbing from the kids? We have no choice.
The red lunch box is in there.
We're rats. Jimmy's gonna be hungry tomorrow morning.
Whoever got the Door Explorer is really gonna be there.
Somebody's gonna have to take it early that night.
Yeah. We gotta do what we gotta do.
I would really consider
It's west, it's where I live.
I'm gonna lose that right
I hate telling about it.
When she goes back outside, it's cold. She could go out there and freeze to death.
You guys are aware of the Ellen Giggs internet here, the maintenance service.
You can use a hotspot on your
So I'm still, with all the Wi-Fi, so I tried, the Wi-Fi doesn't work, the upload speed's too high. You can't get enough, even the Wi-Fi.
For a hotspot?
Even for the Wi-Fi here, it's like 600 or 700 megabytes, it won't do it, it won't upload it, because there's too many Wi-Fi signals in there. It diffuses my Wi-Fi signal before it gets.
So if everybody turns off their Wi-Fi, we can be able to do it?
Not here, because I don't think a tone's been uploaded. It's uploading high def, but I recorded the meeting, so I'll upload it when it's done, I'll have the record. So I need to do the maintenance. That's what it is.
Oh, really? You see the resemblance? Yeah. There are many people.
I'm like, I can't. Much.
White Castle. Oh. I know. Yes.
The bill should
He said you'll never drive it again. That thing sit back here. I had to go to, remember when GE? I mean, I got.
It's 4 hours. They probably want to go up to 3.5. Better set that right now. Make sure it does go off. I don't guess what.
Very trash.
And I come on.
Just like the house. You're back, pick your stuff up. Yeah.
And they don't understand whatever you get on there.
Yeah, so you make it, I got $5.
What? Sorry, I was slamming.
I remember we lived in those, and I watched that.
Oh, wow.
I've never seen. I mean, that's how it was always. I was
No, they need to take their time.
It's usually telling us.
Yeah.
5 out of. It's like
I'm good. I actually don't, I got a meeting at.
It's a pretty great this one. It was fast. Yeah.
That's a first.
You want my sweater? And she goes, no, it's on the floor. And I was like, what? She's like, no, it's on
Okay, fair point. I have been there before. I was fair boss up here in here. You know, who does my guilty of.
Couldn't match it all up.
I got it.
Drew shows how.
We lived in Drew for a year. They had to come up with like one day they had to go up the street to that's until I'm ready.
Oh, it started.
She's out of their shoes.
I mean, it's still.
You say yes.
What?
I'll say. Janet.
I figured we were gonna blow it out.
Yeah.
So, I can't interpret you.
Recent record, yeah.
Go. I think I went to Bob the Hill and shut it all down. I told, yeah, I said, I told her. You're right. Yeah, they tried to call it G. We weren't supposed to conflict. We said stick together.
It comes in and get it, and then it fell. Then he started to wrestle. He thought it was another guy. You notice Otis was the only one married. Was he? He was the only one married.
She lived
No, just Friday. They was on there. Used to be.
Yeah, because it is.
It comes on sick. Well, they'll be on.
Oh, I bet he
already texted. They got a guy that was 4 days.
No, unfortunately, it's supposed to.
It's hard to think.
We were right from the.
That truck's before.
I mean, it was pretty cool to see. He's killed. The dog got loose. It's the only reason you would move that fast. The dog got loose.
12 feet.
Did you winterize your camper on? Yes, we winterized it when we got in your. Yeah. Mine's been winterized.
They're blocking the lane for me.
Yeah.
It's a 16. It is good. I mean, it's good. Like, you gotta look through the chicken. There's
My uncle worked for Miller and bring the damn truck.
Over the counter when you stop quick. He never let out. Stuck in the poster to the trail. We built the machine next day. We were there 2 days.
I tell me build it, stack the trailer and all that. Yeah, 'cause it was a Friday.
Right now. The next morning.
And that's it. Drive on there. I work turn around. Good night.
Yeah, and then we had a match. So much of that season. Bob, you know,
Something easier. Not necessarily that I can. One trip.
I bet him draw straws. You got it. I had a video of it. I had a video of it. I had it right. He wrote it. Around my house.
And I had to move my house. 80 times. It's perfect. Wait.
Time I fall out.
Where they cut you off there.
Yeah, that's where exactly. So I get
I ain't watching that shit. We did like
So I
We're running up to.
You got like Harvey Cooper.
Anyways, don't go like your permit, jump you off there.
you just missed.
30 miles north of us. It's like 20 run to all the way to
I was dying.
I did that on.
Oh, yeah, that went.
Like I'm running, like.
Oh, I have two of these. With like two.
I am listening to someone else, even social studies. And I said, this I'm watching.
Scary,
She might have
But like.
I passed his school. I never let out every time.
Bailey.
You guys do this. So I got outside.
Last 2 months.
You stop sucking. I said, we ain't been waiting. We've been trying. Because so anyway, I turned out. I run out through running to Knoxville. I take the orange, we go to Charlotte, and go around Rock Hill, find out 30 inside of South Carolina. Unload the super
Whatever.
You still can if you still can if you don't go out to 7 or 8
Like, what's the?
Whenever I started driving,
I can't tell you.
You will. I'm scared.
Get out of the wall.
We work as a firefighter. We'll get you off the ground.
Already, dessert. We came to Gerardo and St. Louis. It was like maps, like 91 houses. Parent company here in California, yards and pictures. Oh, it's still like we've got 20 show English trailers. We're going back home and start dropping them off. I'm gonna go home and another guy.
Yeah. Are you done?
You got.
Say again? Yeah, they're the same. Yeah, they're the same.
They're the same. You don't need that anymore.
Thank you.
Oh, that closest.
So when you need more time, take more time, but when you start to talk about this, like, make sure to get it all. That's fine. And I was trying to read it. Sure, like,
And even the hallway.
Do we need to reconvene?
Hold on, Scott. That's stay with you. That's stay with you.
No, it's still not working.
Oh, it's not on.
Hey, it's working. See, I fixed it.
You don't need to reconvene because you never closed your session.
They're still got
Or was that why it shut down? Yeah, so did you have time to review all your documents? You feel like you're ready to make some findings on the record?
Yes, ma'am.
I think so.
Okay, go ahead.
Believe that we're here to make a decision based on the investigation that has been conducted. I think this is kind of comes down to 4 different situations. One is malfeasance. I believe this does apply to chief benefactions. I believe the second one is misconduct in office. I believe this does not apply. The third is tampering with evidence. I believe this does apply when we go in section 10-8-1 in our company policy. I think that it does apply. And the fourth is unauthorized use of property. I kind of didn't feel that applied. So there was 2 of the 4 situations that we needed to rule on. My feelings are that Chief Bennett would be demoted to captain. That's my feelings now.
Yes.
Kevin would go ahead with his, how you feel about each different charge or.
With everything you said. Promote you to captain.
So someone make a motion to do that. Recommendation.
I'll make a motion to demote Chief Bennett to captain.
Second.
And do a roll call vote. Mr. Brzezinski?
Yes.
Mr. Kern?
Yes.
Mr. Shelton?
I'm not part of them.
He's not voting. Oh, sorry. Habit?
Anything else in the body?
No, you've made your decision. You can close your hearing. Close your meeting.
So he's good.
We're gonna pay the bills,
Captain.
We've
No,
already
we've
done
already
that.
He can come back as captain.
Yeah, so maybe give him some instruction on what you'd like him to do, in terms of returning to work.
He says reach out to Steve, the administrator.
Going on again.
Motion to adjourn.
We have a dawn to you.
Motion to adjourn.
Adjourn.
You ever.
All this stage here.